Judiciary Committee will please come to order, quorum being present. Without objection, the Chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. Pursuant to notice, I now call up the committee report for a resolution recommending that the House of Representatives find William Barr, Attorney General, U.S. Department of Justice, in contempt for refusal to comply with a subpoena duly issued by the Committee on the Judiciary for purposes of markup, and move that the committee reported favorably to the House.
Mr. Chairman, I demand the question of consideration.
Before we read the bill?
I believe this is when the motion lies.
The question of consideration is not debatable. The question is, shall the committee consider the committee report? All those in favor say aye. 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 Opposed? No. The ayes have it.
Roll call, please.
Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes yes. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Gates, you are not recorded. Mr. Gates votes no.
I don't need to. Gentleman from Georgia?
Yes.
Mr. Johnson of Georgia votes yes.
Gentlelady from Florida? Oh. Is there any member of the committee who wishes to vote who hasn't voted? Clerk will report.
Mr. Chairman, there are 22 ayes and 12 noes.
The motion for consideration is adopted. The clerk will report the committee report.
Resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary.
Without objection, the committee report is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Today, we consider a report recommending that the House of Representatives hold Attorney General William Barr in contempt of Congress for defying a valid subpoena issued by this committee. This is not a step we take lightly. It is the culmination of nearly 3 months of requests, discussions, and negotiations with the Department of Justice for the complete unredacted report by Special Counsel Mueller into Russian interference in the 2016 election, along with the underlying evidence. I appreciate the fact that the Department responded to the offer we made to them last week and met with us yesterday in a last-minute effort to reach an accommodation. We heard the Department out, we responded to them in good faith, and after all was said and done, we unfortunately were still unable to reach agreement, and we proceeded with our markup today. As I've said before, we remain ready and willing to consider any reasonable offer made by the Department even after today's vote. But if a letter I received late last night from the Department is any indication, I am concerned that the Department is heading in the wrong direction. In response to our latest good faith offer, the Department abruptly announced that if we move forward today, it would ask President Trump to invoke what it refers to as a protective assertion of executive privilege on all of the materials subject to our subpoena. Just minutes ago, it took that dramatic step. Besides misapplying the doctrine of executive privilege, since the White House waived these privileges long ago, and the Department seemed open to sharing these materials with us just yesterday, this decision represents a clear escalation in the Trump administration's blanket defiance of Congress' constitutionally mandated duties. I hope that the Department will think better of this last-minute outburst and return to negotiations. As a co-equal branch of government, we must have access to the materials that we need to fulfill our constitutional responsibilities in a manner consistent with past precedent. This is information we are legally entitled to receive, and we are constitutionally obligated to review. And I would remind the members that the Mueller report is no ordinary run-of-the-mill document. It details significant misconduct involving the president, including his campaign's willingness and eagerness to accept help from a hostile foreign government, numerous misstatements, if not outright lies, concerning those acts, and 11 separate incidents of obstructive behavior by the president that more than 700 former prosecutors have told us warrant criminal indictment. If Congress is not entitled to the full unredacted Mueller report, one must wonder what document we would be entitled to. Our exhaustive negotiations with the Department of Justice have unfortunately left us back where we began, with unprecedented obstruction by an administration that has now announced its intention to block all attempts at congressional oversight of the executive branch. It is our constitutional duty to respond. Let me be clear. The information we are requesting is entirely within our legal rights to receive and is no different from what has been provided to Congress on numerous occasions going back nearly a century. But we do not need to go back that far to find the precedent. As recently as the last Congress, under Republican control, the Department produced more than 880,000 pages of sensitive investigative materials pertaining to its investigation of Hillary Clinton, as well as voluminous other material relating to the Russia investigation and other ongoing investigations. That production included highly classified material, notes from FBI interviews, internal text messages, and law enforcement memoranda. With respect to grand jury information, in past cases involving allegations of presidential misconduct or misconduct by other high-ranking public officials, the Department of Justice, as a matter of course, has sought the permission of a court to release relevant information to Congress, if not to the public. Notably, this includes several cases that were not impeachment inquiries, including the investigation into former Agriculture Secretary Mike Espy and the Iran-Contra investigations, as well as other investigations that were not governed by the independent counsel law. But no matter the fact that the law and history clearly support the release to Congress of this kind of information, the Trump administration has taken obstruction of Congress to new heights. Unfortunately, the Attorney General has been all too willing to support the President in this endeavor. I would also like to respond to two of the concerns often raised by my good friend, the Ranking Member. He asks, how can the committee hold the Attorney General in contempt for merely complying with the laws on the books? And how can we hold him in contempt when I have refused an offer to allow me to see certain redacted portions of the report? The answers are simple. First, we issued a valid subpoena for the full report and all of the underlying evidence. The Department has come nowhere close to satisfying its obligations under that subpoena. The Department has never cited a legal basis for withholding the underlying evidence, including last night's threat to invoke executive privilege, which was utterly without credibility, merit, or legal or factual basis, as is, of course, the assertion of, or the statement that they will assert executive privilege by the White House this morning. To the extent that we have asked for access to grand jury information, which is protected by federal law, all we have ever asked is that the Department join us in petitioning the court to determine if it is proper for us to have access to this material. The Department, as I said, has done this on many occasions in the past. We asked for a commitment to join us in that effort again last night, as it has done in many previous cases, and the Department refused. Second, with respect to the offer to lift some of the redactions for me and a handful of my colleagues, the Department has placed unacceptable limitations on access to that information. Their offer would block the members of this committee from reading those sections of the report for themselves. It would require me to leave my notes behind at the Department of Justice. It would prevent me from speaking with my colleagues, with other members of the committee, about what I might see. What good is it? Of what use can this committee make of information that I have but can't discuss with any other member of the committee? I have consistently stated that if we are to do our jobs as members of the House Judiciary Committee, all of the members require meaningful access to the report and the underlying documents. We need to be able to confer with each other about what we have seen. We need to be able to take official action on what we have seen, if warranted. And if necessary, we need to be able to inform a court of law of what we have learned, even if perhaps under seal. If we can find an accommodation that satisfies those basic principles, I would be happy to continue negotiating with the Department of Justice. But now, by invoking executive privilege on all of the material subject to our subpoena, that process has come to a screeching halt. The administration has announced, loud and clear, that it does not recognize Congress as a co-equal branch of government with independent constitutional oversight authority, and it will continue to wage its campaign of obstruction. When the administration says it will oppose all subpoenas, presumably regardless of its merits, it is saying that it does not recognize Congress having a constitutional oversight authority over the executive branch. And to those who consider the matter case closed, in the words of some of our leaders, and who urge us to simply move on, I would say that to do so is to announce loud and clear that such a course of action has the effect of aiding and abetting in the administration's campaign of total, blanket, and unprecedented obstruction. The Trump administration and its enablers may brazenly try to cover up the misdeeds uncovered by the special counsel. But in this committee, we will represent the American people and ensure the truth is known. I urge my colleagues to think about how the Department's latest position and their insistence on ignoring our subpoena affects our committee over time. Our fight is not just about the Mueller report, although we must have access to the Mueller report. Our fight is about defending the rights of Congress as an independent branch to hold the president, any president, accountable. Every day we learn of new efforts by this administration to stonewall Congress, and through Congress to stonewall the American people. The Ways and Means Committee has been denied the president's tax sued in his personal capacity to prevent him from acquiring certain financial records from the Trump Organization. The President has stated that his administration will oppose all subpoenas, and in fact, virtually all document requests are going unsatisfied. Witnesses are refusing to show up at hearings. This is unprecedented. If allowed to go unchecked, this obstruction means the end of congressional oversight. As a co-equal branch of government, we should not and cannot allow this to continue, or we will not be a co-equal branch of government. I urge my colleagues, whether or not you care to see the full Mueller report, and we should all want to see the complete report, to stand up for the institution we are proud to serve. I expect that we will have a full debate today on the measure before us. I hope that at the end of it, we will do what is right. No person, and certainly not the top law enforcement officer in the country, can be permitted to flout the will of Congress and to defy a valid subpoena. No person, not the Attorney General, not the President, can be permitted to be above the law. That is what is at stake today. I urge all of my colleagues to support this report. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, and to the folks watching here, this slog continues. Last week, I urged you and my fellow members of the Judiciary Committee Democrats to respect the histories and traditions of this committee and conduct its business accordingly. We still have a crisis on our southern border. China is stealing our intellectual property, yet here we are, wasting another valuable week of legislating calendar against the majority's war against the administration. Today, we are meeting to consider a resolution to hold Attorney General Bill Barr in contempt of Congress. So let's take just a few moments and go through this. What is the justification for holding Attorney General Barr in contempt of Congress? Perhaps that he failed to abide by the special counsel regulations? No, he went above and beyond what the regulations required by transmitting the full report to Congress with limited redactions. Could it be that the Attorney General failed to accommodate the chairman's demands for information? No. He offered to let the chairman and 5 other Democrat leaders review the less redacted report at the Department of Justice, including a 99.9% unredacted volume on obstruction. In an odd move for anyone demanding access to information, the chairman and the other elected Democrats given access have declined to view that report. The Attorney General also volunteered to testify before this committee about the report's conclusions and his role in sharing the report. And as we all witnessed, the Democratic gamesmanship forced the Attorney General to forego the scheduled hearing last week. On Monday, the Justice Department offered to meet to discuss accommodations. Yesterday, they made a reasonable offer to avert this spectacle, and once again, they were rebuffed and the chairman declined. Perhaps then the Democrats believe that there has been an unreasonable delay in the Justice Department's response to their subpoena. No, that's not true either. In fact, the chairman is moving to this contempt resolution at lightning speed. It has been less than 20 days since the chairman, Nadler, subpoenaed documents from the Justice Department. When the Oversight Committee held Attorney General Eric Holder in contempt, more than 250 days had passed between the subpoena and the committee's vote to hold him in contempt. More than 450 days passed between the committee's initial request to the Justice Department and the committee's contempt vote. Judiciary Democrats are moving more than 10 times faster than Oversight did with Holder. They have moved from request to contempt vote in only 43 days. And yet the Justice Department is still at the negotiating table waiting for the Democrats to arrive in good faith. Why this rush? Without any valid legislative or administrative reason, we can only assume the Democrats that are led by the chairman have resolved to sully the Bill Barr's good name and reputation to accomplish 2 goals. First, Democrats are angry the special counsel's report did not produce the material or collusions they expected to pave their path to impeaching the president. I feel compelled to remind everyone the report found, despite offers to do so, no one from the Trump campaign knowingly conspired with the Russian government. And you can't help but notice the phrase Russian collusion has vanished from the Democratic talking points and left a void in the narrative. Since the special counsel did not make a prosecutorial determination of obstruction, which was his job, the Attorney General and the Deputy Attorney General did so according to their mandates as law enforcement officials while giving no credence to the Office of Legal Counsel's opinion regarding that of sitting presidents. As a result, they're angry. They're angry our nation's chief law enforcement officer and his deputy had the audacity to decide the evidence didn't support charges for obstruction and investigation into something the president didn't do. Second, Democrats are afraid of what the Attorney General will find when he completes his ongoing review of FISA abuses at the Justice Department, including how the Russia investigation began. Multiple news reports have suggested those conclusions could be explosive, could end careers, and could even lead to criminal prosecution. Rather than face that, the Democrats have resolved to neutralize Bill Barr by attacking him and the office and his integrity and his career. This is the first step. What a cynical, mean-spirited, counterproductive, irresponsible step it is. Meanwhile, our economy is surging, unemployment among several minority groups is at historic low. A recent Washington Post poll shows cratering support for impeachment, but Democrats have no plans, no purpose, and no viable legislative agenda beyond attacking this administration. The House is more than 4 months into a Democratic majority. How many bills passed by this committee have been signed into law? Mr. Chairman, I implore you to see reason. I ask that you recognize the craven and insincere politics that seem to be yielding no dividends for the American people. We've talked on multiple occasions and proved at last week's pharmaceutical markup that I stand ready to work with you to promote solutions. I will not, though, become a bystander as we assail the Attorney General and this committee. Our democracy deserves better. Finally, Mr. Chairman, I'd like to quote a fellow member of Congress. As a member of Congress, I treat assertions of executive privilege very seriously. I believe they should be used only sparingly. In this case, it seems clear the administration was forced into a position by the committee's insistence on pushing forward with contempt. Despite the Attorney General's good faith offer, Mr. Chairman, it did not have to be this way. We could have postponed today's vote and accepted the Attorney General's offer. Instead, by not honoring the Constitution's charge to seek accommodations when possible, the prestige of this committee has been diminished. As a result, that should concern us all. I quote Elijah Cummings. In that case, of course, the committee did seek accommodations. In this case, this committee did not. And in just a difference of opinion between me and the chairman, there has been no escalation of this except on the side of the majority. You have to have both sides at the table for accommodations. That's the way this process works. That is what I've just laid out, 10 times faster than even Eric Holder. And when we get into the other issues that have been discussed here, and again, how we deal with this is going forward with what will be the precedent for the future and will be the precedent for what we have. With that, I yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General.
The amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute contains a technical change to page 2 of the committee report. It simply changes the reference on that page to Judiciary Committee to the Committee on the Judiciary. With this modest change, I urge the committee to support the amendment. I now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment.
On the amendment itself, I thank you, Mr. Chairman. I don't have any as far as the amendment nature substitute. I will make one comment that was made in your previous opening statement. The chairman of now the Oversight Committee was not sued in his personal capacity. He was served in his official capacity in that committee. And just a clarification for the record there as we go forward. With that, I have no objection to the ANS.
Are there any amendments to the amendment in the nature of a substitute? Who seeks recognition?
Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Mr. Chairman, I move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Our Democratic colleagues seem to be on a mission. They're determined to destroy Attorney General Barr, or at least discredit him in the eyes of the American people. The Attorney General agreed to appear before this committee last week and was ready to answer any and all questions about the Mueller report. However, Mr. Chairman, you and your Democratic colleagues on this committee decided that instead of just answering questions from members of the committee, well, we unprecedentedly were also going to require him to be grilled by a bunch of partisan staff lawyers. Of course, the Attorney General wisely said, no way, and now you're determined to find him in contempt. In my view, as somebody who served on this committee for 23 years, I think it's disgraceful. Last week, when the Attorney General refused to show up for this committee's kangaroo court, the majority set up an empty chair, ate chicken, and pretty much made a mockery of this committee, a committee that was once led by the likes of Daniel Webster. It's worth noting that Attorney General did appear before the Senate Judiciary Committee the day before he was scheduled to come here, where the unreasonable demand that he be queried by staff attorneys was not made. Senators did the questioning themselves, as is normal, and the same should have been the case here instead of Chickengate. And let's be clear, it wasn't a day at the beach in the Senate for the Attorney General. The senators themselves were perfectly capable of being rude, abusive, and arrogant all by themselves. They didn't need their staff to do it for them. So why this passion to tear into William Barr, an Attorney General, at least up to this point in his career, considered a person of upstanding, in fact, outstanding character. Well, first, our Democratic colleagues are apparently really ticked off about the Mueller report, that it found that the whole Russian collusion thing was a big fat zero. And even though the obstruction of justice allegation wasn't as clear-cut, Special Counsel Mueller found that there was insufficient evidence to pursue a charge against President Trump or against anyone else for that matter. Excuse me, William Barr did that. So Democrats are mad about that, but what I think is even more important is that our Democratic colleagues are afraid. They're afraid that unlike former Attorney General Sessions, who had recused himself from anything related to the Mueller investigation, Bill Barr is going to dig into the origins of the bogus Russian collusion allegation itself. The Clinton campaign funding of the Steele dossier was the actual collusion between the Russians and the political campaign. Is that something that's finally going to be looked into? That was the real political collusion with the Russians. The FBI's involvement in trying to tip a presidential election in favor of one candidate over another, the whole Peter Strzok, Lisa Page, all of that. The idea that Trump may have been right, that his campaign really was spied on by elements of the Obama administration, despite the fact that this accusation was met with such derision by most of the mainstream press at the time. The bottom line is many Democrats on this committee, and in fact many Democrats in both the House and the Senate, apparently believe that finding out the truth in these matters may not be helpful to them in the upcoming election cycle. And the best way to undermine the results of the investigation, the true investigation, which is really about to happen, might just be to destroy the credibility of the guy who's doing the investigation, the Attorney General, William Barr. And let's begin that process, apparently according to the folks on the other side of the aisle, and the chairman included, by finding him in contempt. That's the way we can really discredit him. At least that's the way I see it. And I yield back.
Before I proceed to the next statement, let me just clarify a point of apparent confusion. We are not proposing to hold the Attorney General in contempt for not showing up last week. He didn't show up last week, but that has nothing to do with this motion for contempt. We are proposing to hold him in contempt for ignoring or for not satisfying the subpoena for the production of documents, namely the unredacted Mueller report and underlying evidence. Who seeks recognition?
Mr. Chairman.
Gentleman from, the gentlelady from Texas. For what purpose does the gentlelady from Texas seek recognition?
Like the last word.
Gentlelady is recognized. Thank you.
I'm pausing for a moment because I do think this is a moment in history. And I appreciate my good friends on the other side of the aisle. But having received a letter both from a copy of the letter to the President of the United States by General Barr and a letter from the Department of Justice indicating after their purposeful collapse of the negotiations, well-intentioned by the staff and House Judiciary Committee, I can only conclude that the President now seeks to take a wrecking ball through the Constitution of the United States of America. For the first time in the history of the United States, a president is now exerting executive privilege over every aspect of life that the American people desire to have information. Whether or not their Affordable Care Act is dissolving the pre-existing condition, whether or not children are being separated from their parents, whether or not the environment is being destroyed, anything that the Congress wants to do on behalf of the American people is now being alleged to be under the jurisdiction of privilege. Then, of course, we have to surmise that this is an absolute lawless behavior by this administration. The Attorney General actions are contemptuous and insulting to Congress, but we're simply the tools it is to the American people. To broaden the executive privilege and ignore the constant accommodations that Chairman Nadler has made and our staff in working to work out three simple points. Give us all of the documents, unredacted Mueller report, for the American people to see. Work with us on grand jury materials not to undermine, if you will, any ongoing investigations, and work with us to list the documents by priority. That is very simple. To recount facts of yesteryear does not even speak to the fact of the hundreds of investigations that my good friends, when President Trump and the Republican House and Senate existed, they never ceased. They never ceased going after Secretary Clinton, getting 880,000 documents in a Benghazi hearing that went forever and ever and never found anything. I happen to believe 700 former prosecutors who indicated that the Mueller report describes several acts that satisfy all elements for an obstruction charge conduct. Congressman Jackson Lee didn't say this. Chairman Nadler did not say this precise statement as a former federal prosecutor. It's 700 who've indicated that the actions of this president warrant an obstruction charge. In addition, we have a right to understand the underlying reasons regarding the collusion report. But the very fact that the collusion part of the Mueller report recounts the constant interaction of Trump operatives with Russian adversaries, the American people should be wary, and they should ask us why. And we should write legislation, as I've introduced H.R. 2353, that says if you interact with a Russian operative or foreign adversary as a campaign committee or candidate, you must report it to the FBI. And so this is part of our legislative work. And I would argue the case that our friends on the other side of the aisle should not be noted in history of standing at the door of justice in this room and putting up a stop sign that we cannot pursue the truth on behalf of the American people. We have gone over and over and over again that there are allegations of obstruction of justice that need to be heard in front of this committee. I say this, Mr. Mueller, a former Marine, a man of integrity, I will say to him in the open proceeding, we welcome you to come and explain your position on how disturbed you were that the Attorney General characterized your report as an exoneration of this administration. Secondarily, I want to say to Mr. McGahn, you are a private citizen. You have every right to present yourself to this body. And also that the conduct of President Trump described in Special Counsel Mueller's report would, in the case of any other person, if not having the Office of Legal Counsel policy against indicting a sitting president, would result in felony charges. There are people incarcerated right now because of lesser charges. I don't want to target the president, Mr. Chairman. I simply want to find the truth for the American people, and that's why we're here today to vote on this citation for lacking of producing of documents. I yield back.
Chairman. Mr. Chairman. Mr. Chairman.
Gentleman from Wisconsin, for what purposes does the gentleman seek
Move to
recognition?
strike the last word.
Gentleman is recognized.
Mr. Chairman, I think we ought to step back from the political rhetoric and ask exactly what this contempt citation deals with. And I'm going to try to use my time to do that. First and foremost, and most concerning to every American, or at least it should be, is the fact that they want an unredacted report that includes information on grand jury testimony. The committee, by making this insistence and issuing this subpoena, is telling the Attorney General of the United States to commit a crime, because it's a crime for anybody to disclose grand jury material to anybody else. That includes the Attorney General, it includes the prosecutors in the Justice Department, it includes the witnesses who have been subpoenaed and have testified before the grand jury. It means everybody. And if the grand jury system is to work, and remember, witnesses can't even bring their attorneys into a grand jury, then the secrecy is going to have to be maintained. Now, all of us know that it's really impossible for the people who work on this Capitol Hill to keep a secret. If there is an unredacted version, completely unredacted version, including the grand jury testimony, which is unredacted. It'll be on the front page of every newspaper in the country within 48 hours and talked about incessantly on the cable news shows, whether you watch Fox News or whether you watch MSNBC. Now, I think it is absolutely shocking that the majority of this committee is going to ask the chief law enforcement officer of the United States to commit a crime. Shocking. And there are no exceptions to what is to be disclosed in this unredacted version. That includes the grand jury testimony. And by citing the Attorney General of the United States for contempt of Congress, for saying, I'm standing up for the law, I am not going to break the law by complying with that part of your subpoena, shows an overreach on the part of the majority. If we are to be a government of laws and not of men or people, then we have to obey the law on this end of Pennsylvania Avenue as well as on the other end of Pennsylvania Avenue. And we are not doing that. Now, what else has been redacted? There's been redactions relative to ongoing investigations. Now, do we want to let the people that the Justice Department is investigating know all about the ongoing investigations? I don't think the public interest is served by that. Whether somebody is guilty or not should be determined by the jury in a trial. That's what the American system is, and that's what a lot of the Bill of Rights protects. You also have a protection against people who are peripherally involved in that. And that they were just on the edges of this. They were interviewed, and nothing came of the interview because they didn't have any evidence on what was being investigated. But there's a character assassination squad running around this town that even if you were on the periphery and went and voluntarily talked to the FBI or Mr. Mueller's team, you know, you're going to end up having your good name and your reputation smeared even though you didn't do anything. So this is definitely an overreach. Those redactions, ended up being justified redactions, and I can understand the reluctance on the part of the Attorney General or anybody else that watches the way this institution and the people who work here operate, that anything that is supposed to not get out in the public realm will get out in the public realm with a leak. And if this place weren't as leaky as a sieve, I would not be opposed to what the chairman is doing because I've stood up for oversight during my entire career in this body. But it is leaky as a sieve. And I think what we're doing here is forcing the Attorney General to break the law, to place in jeopardy innocent people, you know, who are not involved in any of the things that Mr. Mueller ended up investigating, and shaming ourselves in the process. My time is up.
For what purpose does the gentleman from Tennessee seek recognition?
Strike the last word.
The gentleman is recognized.
Thank you, Mr. Chair. The Attorney General has been contemptuous of this committee and of the Congress. He was contemptuous last week when he didn't come, when he couldn't dictate the terms of the hearing. He's contemptuous this week when he will not bring forth papers. The chairman has tried to reach an accommodation with the Justice Department. All cases in the past when such issues have been raised about grand jury testimony, the Attorney General has gone with the majority party, the chairman, to the district court and asked that that information be released to the committee for its purposes. This Attorney General has not done that. If he would have done that and tried to make a reasonable accommodation to join with us in going to Judge Howell, we might not be in this situation. But there's been nothing reasonable from this Attorney General. Mr. Sensenbrenner talks about people on the periphery. We don't know who those people were, but we know that Bill Barr decided who was testimony, which testimony would be redacted because people were on the periphery and to protect their reputations. This is the same person who gave a 3.5-page summary of the Mueller report that did not, according to Special Counsel Mueller, who knew it better than anyone else, reflect the character and the spirit of the report. And he knew Mr. Mueller objected to it for not being an accurate representation of his work, and yet he did it. And when asked about it by Mr. Christ in committee, he had no idea that Mr. Mueller or anybody in the Mueller Special Counsel investigation would have objected. That's not true. He lied when Mr. Christ asked him that question. That's beyond contempt. That's a lie. So we're depending on Mr. Barr's determining who was on the periphery and what their reputations would suffer. We're talking about the opportunity for Congress to do its proper oversight as described in Article 1 of the Constitution, which is being trampled upon. The Trump administration refuses to respond to any subpoenas, destroying Article 1 and Congress's prerogatives. Now, we had a question, I think it was maybe the ranking member said, we should be doing legislation, and how many signatures, how many bills have been signed into law by this committee? Well, ask Mitch McConnell, who has declared that the Senate is a graveyard for all legislation that comes from the House. We have passed outstanding legislation out of this committee. It's gone to the graveyard, where Mitch McConnell, who first kills Supreme Court nominees of the last president of the United States in his 1 year before, and voids and frustrates the constitutional prerogative of the president to nominate members to the Supreme Court, but now frustrates the other house by not having hearings whatsoever. Somebody said we're afraid. Yes, we're afraid. We're afraid of the loss of the rule of law. We're afraid of the loss of the power of Congress to be an independent and co-equal branch of government. And we face that today if we don't stand up. And somebody else said that Russia, there are no connections and nothing with Russian collusion. Well, the Mueller report said there was sweeping and systematic efforts by the Russians to influence our election, and they were done so to help Trump. And the Mueller report showed lots of connections between the Trump campaign and Russia, lots of contacts, and didn't show that he had all of the elements to prove beyond a reasonable doubt that they conspired together. There's a big difference between not having connections and having guilt beyond a reasonable doubt. Then Mr. Trump gets on the telephone with Mr. Putin and has a 90-minute conversation or something like that, where he can see on a phone call that he smiled at him and he gets flattered, and never broaches the subject of Russian interference in our next election or Russian interference whatsoever. That was one of the prime parts of the Mueller report, that the Russians interfered and that our intelligence officials had confirmed and told us, and that our FBI has told us, and that we know they did it in 2018 and they're going to do it more in 2020. But our president did not even mention it to Mr. Putin. That is scary. We are afraid of interference in the 2020 elections, and we need to be. And we need to be because we've got a man who has been suggested might be financially dependent on the Russians. Why would he be financially dependent on the Russians? Well, we now know he lost over $1 billion in a decade in the 80s and 90s. He was broke. No bank would loan him a penny. He was broke. And if it weren't for him being president, he'd be in prison with Michael Cohen today as individual one, and he obstructed justice as the Mueller report says it so. We are in danger. We need to respond, and we need to act for the people of the United States of America. I yield back the balance of my time.
For what purpose does the gentleman from Texas seek recognition?
Ask to strike the last word.
Gentleman is recognized.
Thank you. I'm really here in mourning for a once great Judiciary Committee. I know my first term, 05 and 06, I saw our current chairman as a champion for privacy rights, for civil rights, for Fourth Amendment rights, Fifth Amendment rights, and something dramatically has changed over the years. There was concern back then about too much power through the FISA courts, through the Patriot Act, and we shared a number of those concerns. And now this committee majority is on the wrong side of a very important historic time. We've never had the intelligence community, the FBI, people at the top of the DOJ abusing their powers to create a case against a president where there was none, where assets were actually used to try to set up members of the Trump campaign when there was no case, to try to create a case. We ought to be all over that. We ought to be demanding answers from the FISA judge or judges who were either A, content to have fraud committed against their courts, or were complicit. Maybe it was Peter Strzok's buddy that he bragged about in his text that was going to be the FISA judge that signed warrants where there was no probable cause of anything. This was an attempted coup, and history is bringing that into focus more and more clearly. And what does this committee do about the abuses, the attempted coup? It comes in and decides we're going to go after the Attorney General who's trying to clean up the mess. Christopher Wray sure hasn't. Instead of asking from the intel community, let us see the 100% certain proof you have that Hillary Clinton's personal server was hacked by China. No, he covers it up. Says we still hadn't seen it. Well, they hadn't asked to see it. There is a disaster that has occurred in our justice system, and this committee has oversight responsibilities, and we are abusing those. This motion for contempt is not being done in good faith. I'm not going to call anybody on this committee the names that my colleague from Tennessee just did in violation of our rules of decorum. But the truth is, we know that this committee majority is not acting in good faith. How? Because they're moving for contempt for an attorney general failing to turn over material that this majority, at least some, maybe it's just the staff, but some people know that you can't hold someone in contempt. You can vote to do that, but you can't be in contempt for failing to produce things that are illegal for you to produce. How do we know? Somebody over there knows that this is wrong, is because there was an offer. Look, Attorney General Barr, if you'll join us in going to court and getting a court order so that we can get the grand jury proceedings and evidence, then we will disregard the contempt. Well, that's evidence of a state of mind by the majority that at least somebody over there knows you cannot be in contempt for failing to produce what would be illegal to produce without a court order. You're on the wrong side of history. And there is no joy here in seeing the abuses. I hope and pray literally for the day when we can join forces and quit trying to push this idea of an attempted coup and uncover the abuses that have truly gone on. My time's expired. The committee's has too.
Thank the gentlelady. The gentlelady from Pennsylvania. For what purpose does the gentlelady seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. You know, it's easy to lose focus when the White House and our colleagues across the aisle engage in whataboutism or what is the distraction of the day or even misleading legal arguments. Nobody's asking the Attorney General to disobey the law. We're asking the Attorney General to obey the law and produce the Mueller report and the supporting documentation, the underlying evidence that we've been requesting for a couple months now and that the American people have been awaiting for 2 years. Why is this important? Well, if you think there's no collusion and no obstruction, you haven't read the Mueller report. I admit it's not an easy read, but it clearly states that there was coordination, there's evidence of coordination, it clearly states there are multiple instances of obstruction of justice, and it clearly refers that over to Congress to deal with. Over 700 federal prosecutors have now reviewed that evidence, just the redacted evidence, not even the underlying evidence, and stated unequivocally that it shows multiple instances that would be felonies if it was anyone other than a sitting president. And that's the reason why Mueller didn't charge. He says in his report, it was a sitting president under the rules I'm operating under. I couldn't file charges. That's why it's Congress's job to do something about it. And that's why we're staying focused on our job. I'm not joyful about this. I'm not afraid of where it takes us. What I am is profoundly saddened that we're in a position where we have an administration that is stonewalling, yes, even acting in contempt of not just Congress, not just the rule of law, but the American people. And with that, I yield back.
Mr. Chairman.
Who seeks recognition?
Mr. Chairman.
For what purpose is the gentleman?
Move to strike the last word.
Gentleman is recognized.
Bill Barr is following the law, and what's his reward? Democrats are going to hold him in contempt. I don't think today's actually about getting information. I don't think it's about getting the unredacted Mueller report. I don't think last week's hearing was actually about having staff question the Attorney General. I think it's, as my colleague said earlier, I think it's all about trying to destroy Bill Barr because Democrats are nervous he's going to get to the bottom of everything. He's going to find out how and why this investigation started in the first place. Never forget what Bill Barr said a few weeks ago, 3.5 weeks ago when he testified in front of the Senate Finance Committee. Said a lot of important things, but he said four very interesting things. First, he said there was a failure of leadership at the upper echelon, term he used, upper echelon of the FBI. We all know that's the case. Director Comey's been fired. Deputy Director McCabe fired, lied 3 times under oath, according to the Inspector General. FBI counsel Jim Baker demoted and left, currently under investigation by the Justice Department. Lisa Page demoted and left. Peter Strzok, deputy head of counterintelligence, demoted and fired. Peter Strzok, the guy who ran the Clinton investigation and the Russian investigation. There was certainly a failure of leadership at the upper echelon of the FBI. Second thing the Attorney General said 3.5 weeks ago in front of the Senate Finance Committee. Spying did occur. Said it twice. Yes, spying did occur. Third, he said, there's a basis for my concern about the spying that took place. And maybe the most interesting thing, 2 terms he used that frankly I find frightening. He said there was, in his judgment, he thinks there may have been unauthorized surveillance and political surveillance. Scary terms. We got to go back to January 3rd, 2017. Senator Schumer on the Rachel Maddow show talking about then President-elect Trump says this: if you take on the intelligence community, they have 6 ways from Sunday at getting back at you. Now, I don't know if the FBI went after President Trump in 6 ways, but I sure know they went after him in 2 ways. And the first one is the now famous dossier. On October 21st, 2016, the FBI used one party's opposition research document as the basis to go to a secret court to get a warrant to spy on the other party's campaign. That happened. Democrat National Committee, the Clinton campaign, paid Perkins Coie law firm, who hired Fusion GPS, who then hired a foreigner, Christopher Steele, who did what? Talked to Russians and put together this salacious, unverified document that became the basis to get a warrant to spy on the Trump campaign. They did it. And when they went to the court, they didn't tell them important things like who paid for it. They didn't tell them that Christopher Steele had already told the FBI and the Justice Department that he was, quote, desperate to stop Trump. And they didn't tell the court that Christopher Steele had been fired by the FBI because he's out talking to the press. They did that. And second, just last Thursday, New York Times story, FBI sent investigator posing as an assistant to meet with the Trump aide in 2016. FBI sent someone in, pretending to be somebody else, to talk with George Papadopoulos, who was with the Trump campaign. You know what they call that? You know what they call that? It's called spying. They did it. They did it. They did it twice, and who knows how much more. And what I know is Bill Barr has said he's going to get to the bottom of it. And think about the term he used again. This is important. Political surveillance. In the United States of America, I will not yield. Think about that term. He's going to get to he said he's going to put a team together, going to investigate all this. This is critical. And never forget the guy who ran this investigation, Peter Strzok, ran the Clinton investigation and then launched and ran the Trump-Russia investigation. Never forget what he said. Trump should lose $100 million to zero. We need an insurance policy. Told Lisa Page, don't worry, Lisa, we'll stop Trump. This is what Bill Barr wants to investigate. And as my colleagues have said, this is the House Judiciary Committee, with the history this committee has in protecting fundamental liberties and protecting the Constitution. Last week, there was another important document Emmett Flood sent to the Attorney General. I just want to read a couple sentences. Under our system of government, unelected executive branch officers and intelligence agency personnel are supposed to answer to the person elected by the people, the president, and not the other way around. This is not a Democrat or Republican issue. It's a matter of having a government responsible to the people, to we the people. In the partisan commotion surrounding the Mueller report, it would be well to remember that what can be done to a president can be done to any of us. And this committee is supposed to look out for that fundamental fact more than anything else. And we are not doing that today. I yield back.
I would simply observe that, to his credit, Mr. Jordan has been second to none in asking for access to the materials we're asking for the. And I simply ask him: does he still think is he still supporting his own request for that the committee and the Congress be given access to the entire report and the underlying information?
Consistent with the law, and I would ask the chairman. My understanding is Mr. Mueller's going to be here next week. Why are we doing it? You're going to get to ask the guy who wrote the whole darn document. We're all going to get asked him questions. Why don't you hold off on this contempt until at least the guy who wrote the thing spent 22 months and $35 million with a whole bunch of Democrat lawyers putting it together? Why don't you wait and ask him next week before we do this contempt resolution?
I'll answer, well, essentially because it would be useful to read the material before we have him in front of us. In any event, the gentleman, for what purpose is the gentleman from Georgia seek recognition?
I move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. For most people in America, the end of the Mueller investigation did not equal the end of the story. The American people want to see and hear the full story, and they deserve to do so. And in fact, Investigator Mueller intended for the American people and for Congress to have the full story. He did so in his unredacted summaries for both the obstruction and the Russian influence investigations. And what happened when he issued his report, William Barr did something unprecedented. He put together his own 4-page summary, which was misleading, which failed to properly and adequately and accurately characterize the conclusions of the Mueller investigators. He did that. He waited for about a month while that narrative marinated among the American people, and it was reduced down to 4 words: no collusion, no obstruction. And they ran with that for a month before finally the redacted report was issued by Bob Barr. But before he issued the report, 2 hours before he issued the report, he had a press conference to again summarize the Mueller report's findings. And again, he failed to accurately portray and represent those results. And so finally, the redacted report was revealed to Congress and to the American people, and the American people and Congress saw clearly that Bob Barr was a part of the president's ongoing obstruction. He obstructed the Russia investigation. He obstructed all matters that Mueller was investigating, and now he's trying to obstruct Congress and the American people in finding out what's in that report. And what is very troublesome is my colleagues on the other side of the aisle are aiding and abetting them in their cover-up. So still, the full results of the Mueller investigation are not known. Congress, the House of Representatives, the Judiciary Committee has demanded an unredacted report that should be available to all of the members of at least the House Judiciary Committee. The Attorney General Barr has stonewalled, as he has been instructed to do by the President, and he's a willing participant in this, mind you. They are obstructing the American people's ability to understand what happened. They're hiding behind Rule 6E of the Federal Rules of Evidence, which make grand jury proceedings secret. But as my colleague from Wisconsin should know, there are 5 exceptions listed in 6E that enable the disclosure of grand jury information. He knows that. There's no reason for the American people to be misled about that. And William Barr knows that also, and he also knows that previous attorney generals in his situation have gone to Congress, have gone to the courts with the House of Representatives and obtained grand jury materials when necessary. And so this is all part of a cover-up. And it is up to this committee to ensure that we get that report, because we have lawful responsibilities, constitutional responsibilities to engage in, one of which is possibly impeachment. How can we impeach without getting the documents? So we must get this document. The American people expect us to do it. Once we get it, our hearings can continue and lead to whatever they may lead to, including impeachment. And so I ask my colleagues on the other side to stop obfuscating and start working with us to carry out your constitutional responsibilities. And with that, I yield back.
For what purpose does the gentleman from Florida seek recognition?
Move strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Glad to see that the microphone's working this week. My good friend from Georgia just asked the operative question: how can we impeach if we don't get the documents? How can we impeach if we don't get the documents? Ladies and gentlemen, this hearing is not about the Attorney General. It's not about the Mueller report, 92% of which everyone in America has had the opportunity to read. It's not about the fact that even the portions that the American people haven't been able to read, the chairman's been able to go read had he chosen. This is all about impeaching the president. Now, why don't they just say it? Why don't they just jump to the impeachment proceedings like their liberal media overlords are telling them to do? Well, the reason is that the American people don't support impeachment. And it's easy to understand why. They actually went and elected Donald Trump president of the United States. And I don't think people are going to support impeaching a president who's doing so well. I mean, you got 3.2% growth in the economy. The Trump economy is hot. And the reason we're doing so well is as a consequence of the president's policies. And so at a time when my Democrat colleagues are focused on the next election and not solutions to the problems facing Americans, they can't attack the president's policies because people are doing well. So typically they roll next to identity politics, that based on what you look like, who you pray to, or who you love, you can't possibly support Republicans. But African Americans are doing better. Hispanics are doing better. Women are doing better. We are seeing a rising tide that is truly lifting all boats in this country. And so now we have this effort, not to argue with policies, not to typically go to the identity politics that functions as the organizing principle of today's Democratic Party. They have to delegitimize the guy that won, delegitimize the guy that people voted for. but they don't have the guts to do it directly, and so they're going after the Attorney General. Now, the gentleman from Georgia in his last remark said, we are hiding behind the rules. Hiding behind the rules. These are federal laws that dictate what the Attorney General can and cannot do. We're not hiding behind the rules. We just like to follow them. By the way, it's not following the rules that got us in this trouble in the first place. When the Inspector General testified before us, he said it's the fundamental fact that during the investigations of Hillary Clinton and Donald Trump, you saw continuous examples of a one-off here, a violation of protocol there. The Inspector General said never before had he seen a circumstance where the very same team that was investigating Hillary Clinton would then go and investigate the other person that was involved in the 2016 presidential contest. About a month ago, in this committee, I laid out the stages of grief: denial, anger, bargaining, depression, and acceptance. And I think that folks watching at home can probably follow along and see where we're headed. First, my Democratic colleagues were in denial. When they saw that there was no collusion after saying for 22 months that the president was an agent of the Russian government, after saying for 22 months that there was actual evidence of collusion, they were in denial when they saw the conclusion that there wasn't. Then there was anger. It had to be the Attorney General's fault. Mueller didn't make a decision on obstruction. Somebody had to. The Attorney General did. So they got mad at him. And we had this whole kerfluffle of anger. Well, now we know the third step: bargaining. Well, Mr. Attorney General, you've given us 92% of the Mueller report, but we have to bargain for the remaining 8% because that's really where we think the action is. Well, Mr. Attorney General, you spent 5 hours before the Senate Judiciary Committee. 3 of our presidential candidates got to question you. You offered to come before the House Judiciary Committee. You offered to come for an additional hour of questioning, but we have to bargain so that our staff lawyers can ask you questions. Now, I don't think it's a good sign that the next sign after bargaining is depression. So I feel for my Democrat colleagues, but after that we get to acceptance, and that's sure something that I'm looking forward to, because there are some really good ideas that my Democratic colleagues have once they kind of get to acceptance on the no Russia collusion thing. My friend, the gentleman from Rhode Island, has excellent ideas about how to change the way that consumers interface with big tech companies. My colleague from the state of New York is right, that if the First Step Act is the only Step Act, then that would be a bad thing. We need to do more on criminal justice reform. My colleague who's not with us from California, Mr. Swalwell, he's got great ideas to unlock potential cures with medical cannabis reform, but we're not doing any of those things. And by the way, I bet a bunch of my friends on the other side of the aisle low-key wish that their actual bills that would impact the lives of Americans would get heard instead of this garbage. The Obama administration ran an intel operation against the Trump campaign. Peter Strzok opened it up, the dossier kept it going, and now the Democrats need to get over it. I yield back.
Mr. Chairman, I move to strike the last word.
The gentleman from Florida. What purpose is the gentleman from Florida recognized? Move to seek recognition.
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you. Mr. Chairman, we're here today because we're witnessing the breakdown of the foundations of our nation's constitutional order. That's why we're here today. In 1974 in U.S. v. Nixon, the Supreme Court warned of moments just like this, when they said, once executive privilege is asserted, co-equal branches of the government are set on a collision course. The court went on to explain that such a collision, and I quote, places courts in the awkward position of evaluating the executive's claims of confidentiality and autonomy and pushes to the fore difficult questions of separation of power and checks and balances. These occasions for constitutional confrontation between the two branches are likely to be avoided whenever possible. Why are we on this collision course today? Because the Attorney General of the United States refused to provide information that is not privileged and is subject to the committee's subpoena. The committee issued a subpoena for information gathered by the special counsel. There's no privilege for this information. Executive privilege is not a cloak of secrecy that drapes across our nation's capital from the White House to the Justice Department. Yet last night, the Attorney General threatened a blanket privilege claim over materials that he knows are not privileged as retribution for the markup that we're holding right now. And this morning, he asked the president to do just that. It's striking how empty that gesture is. Chairman Nadler pointed this out last night. The Attorney General's request of a blanket privilege claim is empty of any credibility. It's empty of merit. It's empty of any legal or factual support. The Attorney General ordered his staff to send what he would define as a snitty letter last night. But those words were empty. Executive privilege exists to help the presidency function, to ensure that the president gets good advice and can make important decisions without interference from Congress. But that's not at stake here. We're asking for information that is no longer held in confidence among the president and his closest advisors. We're just asking for the truth that many already know but is being withheld from the public. Investigators know the truth. Private attorneys know the truth. The ranking member of this committee has seen it. The privilege no longer applies. What does apply is the American people's interest in the truth and the need for this committee to do its job, to protect our elections, to protect our national security, to hold the president accountable, and to draft legislation to ensure that no one, not the Attorney General, not the president, is above the law. Yet the Attorney General continues to mislead the American people. And after being caught in a lie in his testimony to Congress, he has now joined the president in his ongoing obstruction of the House. Congressional hearings and document requests are normal. They're normal. This committee holds an oversight hearing with the Attorney General every year. That is normal. But this collision course the President and Attorney General set us on is not normal. This collision is the definition of a constitutional crisis, and the breadth of this obstruction is beyond anything in our nation's history. The President has said that Mueller should not testify here. He has ordered without authority Don McGahn to refuse to testify here. He has ordered, in violation of the law, that the Treasury Secretary continue to hide his tax returns. He has blocked or delayed more than 30 requests from Congress. He has blocked testimony about the security clearances granted to his family members. He has blocked testimony about the humanitarian disaster caused by the Trump family separation policy at our southern border. This sweeping repudiation of Congress and congressional investigations is unprecedented, and it is unconstitutional. This is a government of, by, and for the people. The Attorney General of the United States is stonewalling the people. He is misleading the people. And he is actively working to suppress the truth. I don't understand, still, every time we have one of these hearings, how it is that none of my colleagues on the other side of the aisle seem at all concerned about Russia's attack on our democracy and their desire to do it again. And I close with this. The Mueller report finishes by reminding us that the protection of the criminal justice system from corrupt acts by any person, including the president, accords with the fundamental principle of our government that no person in this country is so high that he is above the law. We will continue to assert our oversight authority out of a duty to maintain the checks and balances that preserve the powers of separation and co-equal branches of government. A failure to do so would be a failure of our constitutional system of government. I yield back.
What purpose does the gentleman from Colorado seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Gentleman reserves a point of order. Is there an amendment at the desk?
Mr. Chairman,
For what purposes, gentleman from Louisiana seek recognition?
Move to strike the last word.
The gentleman from,
I'll withdraw my amendment because it's not ready at this point. And
I appreciate that. The gentleman from Louisiana is recognized for 5 minutes.
Thank you, Mr. Chairman. We have heard some extraordinary claims this morning. I've been taking notes as my colleagues have commented on all of this. Congresswoman Sheila Jackson Lee said the executive branch is, quote, taking a wrecking ball to the Constitution. And, Mr. Chairman, you said that the DOJ doesn't recognize Congress as a co-equal branch of government or acknowledge our oversight responsibility. Mr. Cohen said we're trampling upon Article 1. Anyone who looks at these facts objectively knows the truth is exactly the opposite. The Attorney General and the DOJ are objecting to this charade based upon the rule of law. They are trying to protect the integrity of our institutions. And, Mr. Chairman, you said that the preliminary protective assertion of executive privilege this morning was a last-minute outburst. It's exactly the opposite of that. In fact, the letter that the DOJ sent to you this morning says, and I quote, regrettably, you, Mr. Chairman, have made this assertion necessary by your insistence upon scheduling a premature contempt vote. The letter goes on to say you've terminated our ongoing negotiations and abandoned the accommodation process. And as we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law, court rules, and court orders, and without threatening the independence of the Department of Justice's prosecutorial functions. That's a quoting from the letter. The facts matter. The letter that the Attorney General sent to the President this morning that accompanies all this says, quote, the committee demands all of the special counsel's investigative files, which consist of, everybody listen, consist of millions of pages of classified and unclassified documents bearing upon more than 24 criminal cases and investigations, many of which are ongoing. These materials include law enforcement information, information about sensitive intelligence sources and methods, and grand jury information that the department is prohibited from disclosing by law. That's the letter the Attorney General sent to the President explaining all this. Look, we're attorneys on here. Most of us are attorneys on this committee. What does the law say? The courts have repeatedly affirmed the rules on all this. April 5th, just last month, the U.S. Court of Appeals for the D.C. Circuit ruled in McKeever versus Barr. The district courts may disclose grand jury materials only where they have positive authority to do so, particularly through the exceptions to grand jury secrecy listed in Rule 6E. The Court of Appeals explained the vital interests, they said, that the rule of grand jury secrecy seeks to protect, including preserving the willingness and candor of witnesses called before the grand jury, not alerting the target of investigation who might otherwise flee or interfere with the grand jury, and preserving the rights of a suspect who might later be exonerated. These are critically important principles and traditions for us to uphold, and it is, again, the law. The chairman can file suit for access to the 6E material, but instead he blasts the Attorney General for not joining him in doing so. Why hasn't the chairman taken that step? I think I know why. Perhaps because he knows that his rationale for demanding the unredacted report is wholly insufficient. Look, this bears repeating. The chairman claims he needs the full unredacted report as part of the March 4th, 2019 investigation into the 81 individuals and organizations related in some way to President Trump. But let's make a couple of facts clear. The investigation, we don't even know if it's still ongoing. We haven't heard much about it lately. The lack of activity surrounding the investigations makes clear the majority here is not interested in pursuing this for any legitimate legislative purpose. This is about scoring political points. The chairman's public comments surrounding his need for the full report are almost exclusively focused on obstruction, but another important fact here, 99.9% of the obstruction volume is available right now for the chairman to view, but he hasn't done that. Only 6 lines and over 182 pages is redacted in the obstruction volume. This is not about seeking the truth, as we've heard this morning. It's about raw partisan politics. Our Democrat colleagues have weaponized our critical oversight responsibilities. And moving today to hold the AG in contempt is not only premature, unprecedented, and unwarranted, frankly, it is shameful. We believe the American people deserve better. I hope that they'll review the facts. I hope they'll look at all this correspondence. I hope they'll get beyond all this cloud of partisan politics and understand why we are taking the stand today that we are. I yield back.
For what purposes, gentleman from Louisiana seek recognition?
Mr. Chairman, I would move to strike the last word.
Gentleman's recognized.
Mr. Chairman, I would just say that today is a very serious day. Today is a very regrettable day. Unfortunately, we have an administration that is choosing to have a temper tantrum that is designed to accomplish one thing. And that one thing is to never let the real facts of the Mueller report come to light, to never let the American people hear the whole story. The other side would have us congratulate them for telling 92% of the story. I wish when I was a child I could get away with telling 92% of the story to my mother. I would always tell the same good 92%. And I would leave all the bad deeds, lies, and crimes in the 8% that I don't tell. So you get no profile in courage. You don't get the Nobel Peace Prize, and you certainly don't get any award for honesty for giving out 92% of the whole story to the American people. But the real story of what we're doing today is that the president needed something to hang his hat on to prevent anyone who had anything to do with compiling the report from putting their hand on a Bible and taking an oath to tell the truth. And that's what we're going to ultimately have, is the president obstructing the testimony of everyone involved in the Mueller report, while he tells the national people and continues to promote and articulate and push and offer lies and fake news about the contents of the report without ever letting the American people see the whole truth and nothing but the truth. But I will tell the American people that are watching today that we have a solemn obligation to the Constitution. We have a solemn obligation to defend our democracy, to protect the homeland, to protect the right of the American citizens to have a free, open, fair election without the interference of any foreign countries, especially Russia. The bad news is that this will never be neat. This will never be clean. This will never be easy. This will never be convenient. This will be messy. But the one thing that the American people should know is that we're here at the right time to protect our democracy, and that the Democrats are not going to give up on our constitutional duty. We're not going to run or abandon this country or our citizens. We will never run. We will never retreat when we're fighting to save our country. And for the messiness, it will be that way sometimes. But the fight is necessary to protect this great country and to continue to move it towards being a more perfect union. There are too many people in this country's history that have given their life, blood, sweat, and tears to get us to be the great country that we are today. We will not let one administration, certainly not one person, we will not let one party be enablers to the criminal acts that we see over and over again. So just so that I can deal and speak in facts, so people won't just think that they're the Democrats go again. There have been 199 criminal acts that have come out of the investigation. There have been 34 individuals charged with crimes. There have been 3 companies charged with crimes. So let's just look at the orbit around this administration and see how fake this is. The former campaign manager in jail, former national security advisor in jail, the president's personal lawyer in jail. This is not a witch hunt. If it looks like a duck, walks like a duck, and quacks like a duck, it's a duck. And if it looks like obstruction, sounds like obstruction, smells like obstruction, it's obstruction. Thank you, Mr. Chairman. I yield back.
Mr. Chairman.
Who seeks recognition? Gentleman, for what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. You know, last week we saw an attempt to change the rules of this committee that defied the historical precedent of by applying only impeachment proceedings to Attorney General William Barr. And today we're zipping right along, and we know that my colleagues on the other side have the votes. They're gonna try to hold this Attorney General in contempt. But I'm interested to see the look on the judge's face when my colleagues from the other side present these facts. The court's going to say, "What'd you do? Were you in negotiations?" Well, we were, but we scuttled that because we refused to hear from the Attorney General because we changed the rules. You know, Judge, we changed the rules so the Attorney General didn't come in. He offered to let us view the less redacted report, but I didn't do that. I didn't even bother to go down there and look at that report. He offered to have staff members view the less redacted report with me. I said, no, we're not going to do that either. He permitted us to take notes on the less redacted report, and we rejected that as well. He asked us to continue to negotiate, see if we could work out our differences, but I rejected that as well. We attempted to compel him to respond in spite of federal law on Rule 6E, the grand jury material we've heard so much about today. We knew that there were some other witnesses that were important that might have shed light on this as well, but we didn't hold a hearing with DAG Rosenstein. We didn't hold a hearing on Mueller before we issued our contempt citation. We didn't seek closed-door, confidential, classified hearings with any of these individuals. In fact, Judge, you know what we did? We undercut our whole argument by making the argument to Mr. Barr, saying, hey, look, you know, Mr. Barr, why don't you just join us? Why don't you just join us in asking the court to authorize release of 6E material? What does that do? It says, quite frankly, that the folks that will be sitting there before a court propounding execution of a contempt citation, they're going to have the great privilege of saying, yeah, we put a sword of Damocles over William Barr. We created a Hobson choice. We said, guess what, Mr. Barr? You either get held in contempt or you violate federal law. Because that's just the way we do things in Judiciary Committee these days. That's just the way it is. That is unprecedented and will hold this committee up to derision. And as my colleague, Mr. Johnson from Louisiana said, there was a case that just came out last month which said, and this gets to my colleague from Georgia who said, you can't be misled, there are exceptions. That's right, and the court said you must fit within one of those exceptions before you can release Rule 6E material. But don't be misled, because nothing we're doing here today fits in to the Rule 6E exceptions. There's not an authorization under the 6E provisions right now. So there's going to be a problem, and I can't wait to see the look on the judge's face when these guys try to explain, well, we were trying to pigeonhole into something that's 6E. And then I'll just close in this area. When I hear that the wrecking ball is being taken to the Constitution, that it's being trampled upon, that we're a continued breakdown of constitutional order, these kind of arguments made over and over again, I can't help but say, if you think this administration, this president is so dangerous, where's
Why aren't you acting on the many resolutions for impeachment you've already introduced? I mean, Mr. Johnson was pretty clear. This whole thing is about impeachment. Well, take it to the American people. Take it, file your resolution. You've already filed them. Act on them. With that, my time is up. Thank you.
The gentleman, for what purpose is the gentleman from New York seek recognition?
I move to strike the last word.
Gentleman is recognized.
Let me first just say that I expect that when the court does hear this challenge, if it comes to that, I expect that she will rule in favor of the constitutional separation and checks and balances in our oversight function. I really don't understand the arguments that have been articulated by my colleagues. And as I understand it, there have been three different reasons that have been suggested for opposing our effort to simply uphold our Article I responsibility as a separate and co-equal branch of government. One, that this whole thing is a politically inspired witch hunt. Nonsense. Two, they want to all of a sudden protect the reputational interests of innocent Americans. Nonsense. Three, this blanket assertion of executive privilege. Nonsense. Let's take all three. First of all, 17 different intelligence agencies have concluded that Russia interfered with our election, attacked our democracy for the sole purpose of artificially placing someone at 1600 Pennsylvania Avenue. They were successful. And that's also what the Mueller report shows. This is not a politically inspired witch hunt. I'm confused. Every single person at the helm of this investigation is a Republican. The person who initiated the investigation, former FBI Director James Comey, Republican. The FBI Director who replaced him and presided over the investigation, Christopher Wray, Republican. The person who decided to appoint a special counsel to preside over the investigation and then monitored it at the helm of the Department of Justice, the Deputy Attorney General, Rod Rosenstein, Republican. The person who actually conducted the investigation, a war hero, a law enforcement professional, Bob Mueller, lifetime Republican. Who is the Attorney General going to investigate? The Republican Party? The notion that it's a politically inspired witch hunt is just one of 10,000 or more misrepresentations that have been spun out of 1600 Pennsylvania Avenue. It's a shame that you choose to adopt it and parrot it. Second thing, reputational interests? Really? Many of my colleagues on the other side of the aisle actually perpetrated a witch hunt as it relates to securing more than 800,000 documents from this very same Department of Justice without regard to the reputational interests of Americans who have served this country. You weren't concerned with the reputational interests of Hillary Clinton. In fact, the top Republican said that the sole objective was to undermine her, the former First Lady and Secretary of State. You weren't concerned with the reputational interests of Peter Strzok and Lisa Page. In fact, you embarrassed those two. They made mistakes, but you embarrassed those two. You weren't concerned with the reputational interests of Andy McCabe. So don't peddle that phony argument to us. This very same Department of Justice turned over 800,000 pages of documents, but they won't turn over a single page pursuant to a legitimately issued subpoena? And then you want to assert executive privilege. Are you kidding me? You can't assert executive privilege after the fact when the closest advisors to the president have already spoken to Team Mueller. Wait a second, let's try to go through this. White House counsel Don McCann talked to Mueller. There's no assertion of executive privilege. White House press secretary Sarah Huckabee Sanders talked to Mueller. No assertion of executive privilege. White House Communications Director Hope Hicks talked to Mueller. There was no assertion of executive privilege. It's a phony argument.
The House is a separate and co-equal branch of government. We're not a wholly owned subsidiary of the Trump administration. We don't work for Donald Trump. We work for the American people. We have a constitutional responsibility to serve as a check and balance on an out-of-control executive branch. The Attorney General is totally out of control. He will be held in contempt of Congress. I yield back.
What purpose does the gentleman from California seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you. Mr. Chairman, this subpoena puts the Attorney General in legal catch-22. To comply with the subpoena, he must break the law. If he obeys the law, he must disobey the subpoena. Now, every person on this committee knows that the law forbids release of grand jury testimony. Congress is the law-making branch of government. If this committee feels it's so important to see the grand jury testimony, it can change the law. But it cannot order the highest-ranking law enforcement official in our country to break that law. You know, the American people can plainly see what's going on here. For 2.5 years, they have been force-fed a brazen and monstrous lie that the President of the United States is a traitor who's loyal to a foreign and hostile power. Robert Mueller was given extraordinary powers to investigate this. He appointed one of the most partisan and biased teams of investigators that has ever been appointed to substantiate these charges. They spent 22 months and $25 million in direct and component costs doing so. They employed some of the most abusive tactics, among them perjury traps and threatening family members, in order to turn up some shred of evidence to confirm this narrative. The Trump administration gave them every document they requested and even waived attorney-client privilege to make the president's personal attorney available for 30 hours of testimony. Though the president had the clear constitutional authority to terminate or interfere with the investigation, he did not. Well, after all that, they were forced to admit that there's not a shred of evidence to support this lie. We're now learning it was predicated on a fake dossier fabricated by the Clinton campaign and was used by the highest-ranking officials of the Department of Justice, the FBI, our intelligence agencies, and perhaps even the White House. First, to try to influence the outcome of our election, and after failing that, to undermine the duly elected President of the United States and tear this country apart. Now that lie's laid bare for all to see. The left's had now to think up a new lie, and think it up quick. Thus, in a heartbeat, the lie changed from collusion to obstruction. That even though the administration did nothing to interfere or impede the investigation, the president is guilty of obstruction just because he complained about the injustice of it all behind closed doors in words that amounted to no action whatsoever. They know this lie won't hold up under scrutiny either. So what to do? Well, the answer to that question is before us right now. Even though there was no legal requirement for the Mueller report to be released publicly, the Attorney General has released it with the sole exception of material he is legally forbidden to release, amounting to 92% of the document. He's offered the chairman and the ranking member of this committee the opportunity to review the additional redactions that can be reviewed in a classified setting, leaving only about 6 lines out of 182 pages. But instead of reviewing that information or changing the law to allow for its public release, they order the Attorney General to do what he legally cannot do and then charge there's a cover-up. They imply the smoking gun is now in that 6 lines and over 182 pages that cannot be legally shared, safe in the knowledge they'll never be called out on it. And they hope that there will be enough of a smokescreen to cover the perversion of our justice and intelligence agencies for political purposes under the Obama administration. One other point. Last week, the Democrats voted to change the rules of the committee to allow members to hide behind committee counsel to challenge the Attorney General. Mr. Chairman, we don't hire people to speak for us on the House floor, and we shouldn't hire people to speak for us in committee. Only members of the House should speak in House proceedings, and there's a reason for that. We're responsible and accountable for what we say in public forums. In this public forum, hired help is not. The only rightful exception is when we sit as a tribunal, an impeachment, because then we're sitting as a jury to hear evidence. Any exceptions from this makes a mockery of representative democracy based on the direct accountability that representatives of the people must have to those who elected them. I yield back.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to begin by thanking you, Chairman Nadler, for your extraordinary patience and determination and respectful manner in which you have sought to obtain the information that the subpoena requires. And I think we all recognize that you have extended yourself above and beyond to try to accommodate the Attorney General. But we are here for one very important reason. And I think people should recognize that this is a deadly, serious moment. The rule of law and our basic institutions that have made our democracy the envy of the world are being tested. The American people are watching, and freedom-seeking people around the world are watching. They're seeing whether or not our commitment to the rule of law, to the notion that we are a country of laws, not of men and women, and that no one is above the law, including the President of the United States. And it reminds us that we fought our independence to be free from a monarchy so that we could live in a democracy. And so we see the President who is attempting to destroy basic institutions of government by directing his Attorney General and others in administration to stonewall the American people. This is a crisis. Now, it's sad today that Attorney General Barr, who has refused to comply with a lawfully issued subpoena, and that behavior is unfortunately consistent with his overt campaign to protect the President of the United States. President Trump wanted his Roy Cohn, and he got his Roy Cohn. The Attorney General has demonstrated that he understands loyalty to the President rather than the oath to the Constitution. The Attorney General tried to shape the narrative of the Russia investigation from day one when he wrote a 4-page document which was grossly misleading, where he took 4 pieces of 4 different sentences to capture a 400-page report. The report also directly contradicts several statements that the Attorney General made during his press conference, which he had before a single person was allowed to read the report. He said the President fully cooperated. We know, of course, the President refused to be interviewed, and his associates destroyed evidence relative to the investigation. He also publicly cleared the Trump campaign of coordinating with Russia while entirely leaving out the critical finding in the Mueller report that the Trump campaign was fully aware and expected to benefit electorally from information stolen and released through the Russian campaign. Since Mr. Mueller has completed the investigation, Mr. Barr has refused to release the full report to Congress, even after the issuance of a lawful subpoena. He's also refused to provide any of the underlying evidence. In fact, he's refused to do anything other than provide political cover to the President. In fact, when he was asked directly about his 4-page summary, he even said that he wasn't aware of what Mr. Mueller's position was on his summary, and we learned later that Mr. Mueller had written a letter criticizing his characterization, and then had a 15-minute phone call doing the same, and Mr. Barr never shared that as well. And so we see an Attorney General who has set out to protect the President at all costs, and now we learn this morning in a letter from Mr. Barr that he's working with the President of the United States to try to provide a legal strategy to further obstruct justice and stonewall the American people by invoking executive privilege retroactively in a context where he knows it is not applicable. And really an effort to say, can we work together to try to prevent the American people from learning the full truth? And you know, it's kind of curious that the President said complete exoneration. You think he would be rushing to get this report released if it really was a complete exoneration, but we know it's not. And so this is a question for us to decide as a committee. Are we going to allow the executive branch to decide for us what we will get to see in order to conduct congressional oversight? If it is up to the executive branch and they decide what witnesses we can call, what documents can be produced, they will have effectively extinguished the right of congressional oversight. We cannot allow that to happen. We are, in fact, here on behalf of the American people to get to the truth, to gather the facts so we can make informed judgments on how to proceed next and what action to take next. We have a responsibility to ensure that people who are served with a subpoena comply with it, whoever you are, no matter how important you think you are. We live in a democracy and everyone must be treated the same. This is a search for the truth that demonstrate no one is above the law, including the President of the United States and the Attorney General of the United States, and that individuals must be held accountable for their misconduct. And so we have to gather up that evidence. I am saddened to hear my Republican colleagues who think this is anything but that. This is our responsibility. We took an oath. Our constituents and the American people are watching us, and the world is watching us. We must do the right thing. We must compel Mr. Barr to comply with a lawfully issued subpoena by this committee and get to the work of oversight, finding the truth wherever it leads us, and demonstrating most of all, in this country, no one is above the law, including the President of the United States. And with that, I yield back.
Mr. Chairman,
Yeah, for what purpose does the gentlelady from Alabama seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, we've heard over and over again how the Attorney General has not accommodated this committee's demands. But let's walk through the timeline. I ask unanimous consent that the full timeline be included in the record.
Without objection.
On March 22, 2019, the Attorney General immediately notified the chairman and ranking members of the House and Senate committees on Judiciary that he had received the confidential report from the special counsel. On March 24, 2019, 2 days later, the Attorney General informed Congress of the special counsel's principal conclusions. On March 29, 2019, 5 days later, the Attorney General updated Congress on the department's review and outlined the 4 categories of redactions that the department, with the special counsel's assistance, intended to make prior to the public release of the confidential report. On April 18, 2019, less than a month after receiving the confidential report, the Attorney General made the redacted version available to Congress and the public. However, on April 18, 2019, the same day, the Attorney General released the confidential report and made the minimally redacted version of the confidential report available for review. Chairman Nadler issued a subpoena to the Attorney General. On April 19, 2019, those House and Senate Democrats invited to review the minimally redacted confidential report wrote the department to refuse the Attorney General's offer. To date, not a single Democrat, including Chairman Nadler, has reviewed the minimally redacted report. On May 1, 2019, the Attorney General voluntarily appeared before the Senate Committee on Judiciary, providing more than 5 hours of testimony regarding the special counsel's investigation and confidential report. The Attorney General had previously volunteered to appear before both the Senate and House Judiciary committees. On May 2, 2019, Chairman Nadler's extraordinary and unreasonable demand that congressional staffers question the Attorney General, a cabinet secretary, in an oversight hearing, forced the Attorney General to forego the hearing. On May 6, 2019, less than 3 weeks after issuing the subpoena, Chairman Nadler introduced a resolution to hold the Attorney General in contempt. Also on May 16, 2019, in an effort to accommodate the committee's interest, the department wrote Chairman Nadler emphasizing, quote, the Department of Justice continued willingness to engage in good faith with the committee on these issues consistent with its obligations under the law. End quote. The department offered to meet to, quote, negotiate an accommodation that meets the legitimate interests of each of our co-equal branches of the government, end quote. On May 7, 2019, the department met with the committee staff to offer additional accommodations in exchange for the committee postponing the scheduled contempt vote, including DOJ would significantly ease restrictions on the review of the less redacted report to allow designated members and staff to more easily review the report and confer with each other. DOJ would expeditiously bring the minimally redacted version of the confidential report to the House of Representatives to facilitate the chairman's review. DOJ would meet next week to discuss the remainder of the committee's request, including prioritized requests for documents. DOJ also signaled it was open to further discussions and accommodations. This was done by DOJ in good faith. Just hours later, Democrats inexplicitly and unreasonably rejected these additional offers. Mr. Chairman, committee Democrats left DOJ with no choice in this matter. They left DOJ with the choice of complying with Democratic leaders' unreasonable demands or complying with the law. The Attorney General elected to follow the law. I yield back.
Gentlelady yields back. For what purpose does the gentleman from California seek recognition?
To speak out of order for 5 minutes.
To strike the last word.
Strike the last word for 5 minutes. Thank you, Mr. Chairman.
The last word is duly struck, and the gentleman is recognized.
Mr. Chairman, I want to remind everyone why we are here. We are here because a report chronicled an attack on America. We were attacked by a foreign adversary. And we have an Attorney General who refuses to give us the details of that attack. So what do you do when you have an Attorney General who prejudged the investigation before he took the job, who refused to recuse himself once he took the job, who falsely accused the FBI of spying on the Trump campaign, who lied to Congress, and failed to comply with the lawful subpoena? What do you do when someone conducts themselves that way? Mr. Chairman, you hold them in contempt. And I would go as so far to say, then you move to impeach him. And you do the same thing to anyone else who doesn't want to follow the law. And I'm not a fortune teller, but with this lawless administration, I imagine we're also going to see characters like Steve Mnuchin, who's also not following the law when it comes to the president's tax returns. And on this issue of executive privilege, Mr. Chairman, once it's waived, it is gone. It is gone forever. It was waived by Don McGahn when he spilled the number of instances when Donald Trump obstructed justice. Obstructed justice, that's a legalese term for acted guilty. A lot. This isn't about executive privilege. It's about burying the evidence, Mr. Chairman. If it was about executive privilege, the Attorney General would not have offered you to be able to view the documents and then tell you that you can't tell anyone what you saw. I thank you for not taking the latest Trump hush offer. We were attacked. We are in an information war with a foreign adversary. And I read the 200 pages of links between the Trump campaign and the Russians. And I also noticed what I didn't read. Not once did it say, by the way, all these contacts have ceased. By the way, all these people in the Trump family, the Trump businesses, the Trump campaign, the Trump administration, the Trump transition, they even managed to work with the Russians during the very narrow transition period. You give them 10 seconds, they'll find a way to find a Russian. That's how it worked. Nowhere in that report did it say, oh, by the way, these contacts ceased. Nowhere in the report did it say, there is no longer an ongoing threat from Russia. Nowhere in the report did it say, the Russians have no further interest in interfering in America. That's why we need this report. And I ask my colleagues, look at the person that you're going to such great lengths to protect. Look at this pathetic person who stood at a press conference as our country was being attacked and said, Russia, if you're listening, you'll be rewarded if you keep attacking. That's the person you want to protect? That's the person you want to break the law for? That individual? And what does this person do after a 400-page report comes out? He calls the leader of the country that attacked us. At his request, President Trump called Putin. They talked for 90 minutes. President Trump described it as Putin was smiling. That's your leader, the commander-in-chief. He called the guy that attacked us. When we were attacked by Japan, Franklin Roosevelt did not call the Emperor of Japan. When we were attacked by Al-Qaeda on September 11th, George Bush did not call Osama bin Laden, and the President of the United States should only call Vladimir Putin for one reason, to tell him that this will never be tolerated, and he's going to unite the country to make sure that's true. The most basic function of a government is to protect its people from a foreign attack. If our president or the Attorney General or his allies in Congress are unable or unwilling to do that, then we don't have a government. Fortunately, we're not powerless anymore. The American people voted to put a balance of power on all of these abuses of power. And this committee is going to protect and defend America, and it's going to start with holding this lawless Attorney General in contempt. And I yield back.
What purpose does the gentlelady from Arizona seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. Members and audience, you know, I ran for Congress to make a difference and get things done. We have a lot of big issues that are problems that are going on in our nation. We have a border crisis. I'm from Arizona. We have lots of humanitarian and border crisis going on. We need to work to improve the education system in our country. We need to work to improve our health care system. It's too expensive. And, you know, when I served 9 years in the Arizona State House and Senate, we actually got big things done. I worked with my Democrat colleagues and my Republican colleagues, and we got issues done, and that's what the American people want us to do. They want us to work together to get things done. And this hearing today does nothing at all to further that cause. In fact, you know, I think that my Democrat colleagues are still in denial that the president was actually elected. I saw it on election night. I stayed up late in Arizona and saw the meltdown of some of the, you know, my Democrat colleagues and the media. And then for 2 years, even before the election of President Trump, for 2 years now, there's been this nonstop saying by my Democrat colleagues and others that, you know, somehow the Trump campaign was colluding with Russia. And they even said they had evidence of it. You know, they said it on TV over and over and over again. Well, it turned out to not be true. So 2 years later, you have the Mueller report, says no collusion, no collusion. So instead of talking about that, which they've done for the last 2 years, now they're changing their tune. And so now it's all about obstruction of justice. Well, let's review, and some of my colleagues have already gone through this, but, you know, Attorney General Barr released the Mueller report. He didn't have to do that. It wasn't the law to do it, but he did it because he did it for the public interest, to release the Mueller report. Again, no collusion. Then the Department of Justice offered for Chairman Nadler to review a less redacted version of the Mueller report. Chairman Nadler refused. He has not gone. And in fact, I think in the volume 2, which is the obstruction of justice part, only 0.1% of the report is actually redacted. Then Attorney General Barr agreed to testify right here in Judiciary Committee on May 2nd. And what happened? Instead of us being able to hear from him and ask him questions, Chairman Nadler insisted that the staff should question the Attorney General Barr, which is unprecedented in this committee. You know, I believe, I don't know, I can't read his heart, but I believe this was done for headlines. I mean, here we had, right there, a blank chair, an open chair with a name tag of the Attorney General Barr, and then we had a member from this committee eat chicken and pose with a ceramic chicken. I mean, this is all political theater and political show that makes for, you know, good TV. But are we getting things done? No, we are not getting things done. And now, the Democrats and Chairman Nadler in this committee are asking the Attorney General to break the law by releasing grand jury information to Congress. So now we're here today, and there's been a movement, a motion to hold Attorney General Barr in contempt of Congress at an incredibly fast pace. From the subpoena to the contempt, 19 days. Let's compare that to Eric Holder. It was 255 days. And we still don't have all the documents from Fast and Furious where a Border Patrol agent was killed. So all I can say is, let's work together and get things done. Let's stop this political theater. Week after week after week, we're just having this theater. The American people want us to work together to work on the big issues. Let's secure the border. Let's improve education. Let's improve health care. Let's stop this political theater. I yield back.
Gentlelady yields back. The gentleman, for what purpose does the gentleman from California seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chair. I'm going to ask 3 questions today. First, what is the Trump administration hiding from the American people? Because the administration is not just stonewalling this committee, they're stonewalling every committee's request for information on behalf of the American people. That is a direct violation of the Constitution. Under the necessary and proper clause of the Constitution, Congress has an absolute right to conduct oversight and investigations on behalf of the American people. In fact, in Federalist Paper 51, James Madison stated that in a Republican form of government, quote, the legislative authority necessarily predominates, unquote. We are Article 1 of the Constitution, and we will act that way. Madison further says that the 3 branches of government were set up, quote, in such a manner as that each may be a check on the other. Today's vote is more than just about the credibility of Bill Barr. It's about the credibility of our entire system of government. And the Democrats on this committee intend to honor our oaths to the Constitution and to the American people. Second question I want to ask, why are Republicans on this committee reversing the very vote they took earlier this year to get the full Mueller report? The House voted 420-0 to get the full unredacted Mueller report, including most of the members of the Republicans on this committee. I'll tell you why. They have now realized that Bill Barr misled the American people because the Mueller report turns out to be bad, bad, bad for the president and his enablers. The report shows that the Trump campaign engaged in numerous contacts with Russian agents, that they knew the Russians were going to interfere in American elections. They welcomed it, they embraced it, and they knew it was going to help the president win the election. That is immoral, that is wrong, that is unpatriotic. And that's just volume 1 of the report. Volume 2 of the report lays out 10 instances at least of obstruction of justice. Over 500 former prosecutors have now written a letter saying that for any ordinary American faced with this amount of evidence, it would have resulted in multiple felony charges. That's why it's so important we get the full unredacted report and the underlying evidence behind these charges, especially because Bill Barr admitted under oath he didn't even read the underlying evidence before he wrote his misleading summary. And I'd like to also now correct a misleading talking point of my Republican colleagues, where they say somehow Bill Barr is complying with the law. No, no, no. The congressional subpoena is the law. How do we know that? That's what the court upheld during Watergate. Leon Jaworski, the special prosecutor, issued a report. Then Chief of Staff Haldeman moved to suppress the report, relying on the same Rule 6E that Bill Barr is relying on, and the D.C. Circuit Court of Appeals held squarely for Congress and said that under this congressional subpoena, the members of the House Judiciary Committee get the grand jury secrecy materials. Bill Barr is violating the law right now. He is not complying with it. The congressional subpoena is the law. That's what the courts upheld. That's what they're going to do. And then the final question I want to ask is, why is Bill Barr suing right now in federal court to eliminate pre-existing conditions health care coverage for millions of Americans? You know, I don't know. But I do know that Democrats are going to pass off the floor this week legislation to protect pre-existing conditions and to protect the health care coverage for millions of Americans. Because it turns out we are doing 2 things. We have passed and will continue to pass legislation to move Americans and the American family forward. And we're also going to conduct oversight as required by the United States Constitution. It is Donald Trump and the Republicans who are stonewalling. I hope they stop doing that, and I yield back.
Gentleman yields back. Who seeks recognition? The gentleman.
Mr. Chairman,
For what purpose does the gentleman from Pennsylvania seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. To say that I'm disappointed in the direction of this committee, I'd say would be an understatement. Echoing what my colleague, Ms. Lesko, said, you know, I was sent here to get things done, and I feel like my colleagues across the aisle have been just chasing a ghost for the last 2 years. During that time, we've suffered from an opioid pandemic. I say pandemic because it's everywhere in the United States. It's killing thousands of individuals. We have real problems to address immigration. We could be moving to a merit-based system that brings us in step with the rest of the industrialized world. And I have 2 bills with Democrat co-prime sponsors that could really make a difference, but instead we're here engaging in political theater, bringing in props, and again, just chasing this ghost for the last 2 years. I have a bill called the Stoic Act with my colleague, Ms. Dean. This would increase grants to local law enforcement for suicide prevention, for PTSD treatment. Law enforcement and first responders need this, and we could actually get this done. This is something that would be productive if we weren't wasting our time. I have another bill with my colleague across the aisle, Ms. Blunt-Rochester. It's called Clean Slate. It would seal the records of anybody convicted of a nonviolent criminal offense, give these individuals a chance to have a fresh start, be productive members in society, and move on once they paid their debt to society. This is something that thousands of people need across the United States. It's something that would help the workforce development in the United States. But again, instead, we're here for 2 years chasing ghosts. So again, to say that I'm disappointed in the direction of this committee is an understatement, especially when we have real work that we could be focused on. With that, I would yield the balance of my time to Ranking Member Doug Collins.
Thank you, and I appreciate the gentleman yielding. I think as we're coming, in a lot of discussions this morning, a lot of things have been pointed out. I want to just sort of sum up, and it's very interesting to me, and I'll just sort of be funny here. We, in this country, we talk a lot about manufacturing and manufacturing jobs and the need for our economy. Well, we now have our committee pitching in because we're manufacturing a crisis. We're manufacturing something that doesn't need to exist and doesn't need to happen. In fact, the reason I know it's a manufactured crisis, I go back to the very words of many on the other side a few years ago, and even my chairman, when they joined a walk-off of the House floor chamber to protest, in his words, the shameful and politically motivated GOP vote holding Eric Holder, Attorney General, in contempt. Walked off, upset, tore up, because we're holding Eric Holder in contempt after almost a year, over a year, 400 plus days, in which accommodations back and forth were made, discussions were made back and forth. So really, we're just manufacturing a crisis because, number one, we didn't get what we want. Number two, we don't like what we got. And there's nothing being hidden here. And yes, the Attorney General is following the regulation. Don't be deceived. He is. It's interesting that we go along, and also that some of the interesting things that's been talked about there. We talk about Nixon impeachment in Article 3, and this has been thrown out by my colleagues. All of the subpoenas issued to President Nixon, and again, a whole different inquiry, which was an impeachment inquiry, were issued after the impeachment inquiry was already started. These were not before the impeachment inquiry, they were after, and that's what we found that. In fact, the impeachment inquiry was opened on October 30th, 1973. All the subpoenas were from April to June of 74. So let's at least get our facts straight. We've had issues, all day today that we've had to sort of correct. Number one being that the chairman now of the Oversight Committee was not sued in his personal capacity. Mr. Flynn is not in jail. He's pled guilty. He is still in that process, but he is not in jail, as was stated earlier. And also, though, I think we've finally come to the conclusion that I think we've all been waiting for, and it was really something interesting to come. And that was that my friend from Georgia actually gave us. And it was really sort of summed up this entire thing. It's what I talked about last week. It's what I talk about now. And my friend from Georgia said, and he brought down the curtain on this entire thing when he said, no documents, how do we impeach? If we don't have the documents, how do we impeach? Because right now, let's be honest, by that very statement, he's making the claim that they don't have enough to impeach because Mueller didn't give them impeachment. The report did not show collusion and did not charge obstruction. There's nothing to impeach. So now we got to dig deeper. And my question is this. An investigation of and I'll agree with my friends across the aisle, from a top-notch investigator, from top-notch attorneys who had unlimited access to a grand jury, unlimited access to subpoenas, unlimited access to investigators, and over $30 million at least in budget, which is larger than any House committee. And we think we're going to find out something more than he found out? Come on, we're manufacturing a crisis, and that's why we're here. And I yield back.
Gentleman yields back. Does any member seek recognition? Gentleman from Maryland is recognized.
Thank you, Madam Chair. Move to strike the last word.
Gentleman is recognized.
Thank you. Madam Chair, Tom Paine said that in the monarchies, the king is law, but in the democracies, the law is king. That is the principle at stake in America today. The President of the United States and all of us who seek and attain public office are nothing but the servants of the people and the servants of the law. And the moment that we forget that and we begin to act like the masters of the people and the masters of the law, then we put our jobs at risk. If the gentleman from Florida is so convinced that the Mueller report offers complete and total exoneration of the president, why doesn't he want the Congress and the American people to see it? Well, he says the Attorney General has only redacted 8% of the report. Madam Chair, you could redact 8% of the Constitution of the United States and get rid of freedom of the speech, freedom of the press, religious freedom, equal protection, and due process. You wouldn't have enough room to get rid of Article 1 of the Constitution, which is, I know, what some would like to do today. But Article 1 is the provision in the Constitution that establishes the powers of Congress, the lawmaking branch, the branch of the people. The president's sole job, primary job after being commander-in-chief, is to take care that the laws are faithfully executed, not circumvented, not defied, and not violated. Now, Madam Chair, I think we need to remark how far this president has lowered our country. First, they destroy the norms and the values of society, things that we'd always taken for granted. You don't mock people with disabilities. Men don't mock women's bodies on television. You don't ridicule people and give them obnoxious nicknames, at least after you graduate from the 3rd grade. You don't falsely accuse other political leaders of treason. You don't accuse other political leaders' parents of assassinating President Kennedy. You don't use disgusting, profane language to disparage other countries, and you don't call neo-Nazis and Klansmen very fine people. You don't give aid and comfort to the dictators of the world like Kim Jong-un and Vladimir Putin by flattering them and being their sycophants. But then you destroy the norms and the values of your office. You call the press the enemy of the people. You call true facts fake news, and you call fake news true facts. You vilify and you demonize the hardworking employees of the Department of Justice and the FBI. You accuse them of being part of a fantasy deep state conspiracy just for doing their jobs. You falsely claim that millions of people voted illegally while you deny and dismiss the finding of Special Counsel Mueller that there was a sweeping and systematic campaign to disrupt our elections in 2016. You refuse to divest yourself of your business interests or to put them in a blind trust, as other presidents have done. You travel to your own business properties and hotels on government expense. You double initiation fees to Mar-a-Lago. You turn the government of the United States into a money-making operation for your family, for your business, and for yourself. And then you violate and undermine the laws of the United States. You sabotage the Affordable Care Act to try to deny millions of people access to their health care. You separate children from their parents at the border. You pull out of the Paris Climate Agreement, making our country an international environmental pariah and outlaw state. You lie about what science has shown about climate change. You call it a Chinese hoax. You collect millions of dollars from foreign princes and kings and governments in violation of Article 1, Section 9, Clause 8 of the Constitution. And now the president, aided and abetted by the Attorney General, tears at the very fabric of our Constitution. He orders that a curtain be pulled down over the executive branch. He says there will be no cooperation with the lawful demands of Congress for information. Congress shouldn't be looking anymore. The President King declares, this is all. It's done. No tax returns, no Mueller report, no witnesses, not Don McGahn, not John Gore. The president declares himself above and beyond the law. The Supreme Court has repeatedly stated that it is an essential and integral aspect of our power under Article 1 to do fact-finding investigations for the people. James Madison said, knowledge will forever govern ignorance, and those who mean to be their own governors must arm themselves with the power that knowledge gives. The people, through the Constitution, gave us that power. We must exercise it. If you act with contempt for the people and Congress, we will find you in contempt of the people and of Congress. And I support the resolution. I yield back, Mr. Chairman.
The gentleman yields back. For what purpose does the gentleman from Virginia seek recognition?
Move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. As I've sat here and listened, it's getting more and more frustrating to me, and I am sure to people watching at home, how distracted this committee is getting from
the issues that truly matter to the American people. And we heard Congresswoman Lesko speak to those. When I get home, my constituents want to know, are we addressing the availability of health care and the accessibility of health care after the skyrocketing premiums that came into place from Obamacare? Are we taking action to reform and renew our highway and infrastructure system to keep up with our booming economy? Are we working to stop the wave of illegal immigration flowing across our borders? These are just a handful of issues that we should be working on. We should be looking at ways to reduce government regulations and find ways to put more money back in Americans' pockets. And instead, my colleagues on the other side of the aisle are calling for more and more investigation, pursuit of documents, even those they're not entitled to receive. And without a judicial proceeding, my colleague from California argues that we are entitled to receive it, not without a judicial proceeding. They are in search of a smoking gun of collusion, conspiracy with Russia that does not exist. Volume 1 of the Mueller report shows clearly it does not exist. Some of my colleagues are running for president on that ghost, on that very ghost, that somehow collusion with Russia still exists somewhere. This report proves there was no conspiracy. I was interviewed a while back, and I said, I hope that as much as possible is released to the American people, because whatever is redacted, they're going to point to and say, aha, that's where the smoking gun is. And sure enough, my colleagues on this committee just 5 minutes ago said, aha, that's where important information must be. Well, without a court order, that grand jury testimony is not allowed to be released. That is the law, and we talk about the rule of law. We talk past each other about the rule of law, but the law is the law, and a subpoena is not the law when it comes to grand jury testimony and whether that can be released. The law prohibiting grand jury testimony from being released is the law. So we cannot see the full Mueller report without judicial action. The chairman can go to court and ask the judge to allow disclosure of 6E grand jury testimony. They don't need the administration to join. They want the administration to join. They say, work with us. But has the chairman, has this committee worked with the administration when it comes to the Attorney General appearing before this committee and getting questioned by staff members recently hired onto the committee? No, apparently not. In fact, the chairman hasn't even reviewed the unredacted version that's been provided. I listened with interest as the chairman mentioned in his remarks how important it is that we all read the report, but he hasn't gone down to read the report. This is a charade, and I have never seen anything like it. 225 days progressed from subpoena of Eric Holder to a contempt vote. This circus, 19 days. It's clear that this is just a game for the majority, and now that they have a bad hand, they're bluffing. Give us the unredacted report. Bill Barr is biased. Don't worry about what the law says. The only bias is the blind hatred of this president and disdain for the rules of this House and the rule of law that is in this Constitution. In the views and actions of the majority, the drive for impeachment trumps all. And yes, if it walks like a duck and talks like a duck, it's a duck. So they're trying to impeach the duck. It trumps the truth. It trumps the historic precedents of this committee, and it apparently trumps the laws of this nation. I am honored to be a member of this House of Representatives. I am honored to be a member of this committee, but that honor has been tarnished by the blatantly partisan actions of this committee today and the willful ignorance of this committee to the rule of law. I yield back.
Cease recognition.
Mr. Chairman, I have an amendment.
Gentlelady from Washington. For what purpose is gentlelady from Washington?
Move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. Mr. Chairman, this is definitely not a game. This is one of the most serious moments our democracy has faced, and it is a test. It is a test against an administration that is continually disregarding Congress, an administration that seems to have no regard for checks and balances. It is unprecedented for a president to say that he will provide no cooperation with authorized subpoenas from Congress, no cooperation with witnesses coming to testify before Congress, and now, just as we've seen in this letter, an unprecedented effort to exert That is part of our democracy. It is part of what our Constitution was geared to do. Our Constitution said we will get our power as members of Congress from you, from the American people who vote us in as members of Congress. And then you give us the power to write the laws of this democracy. Then the Constitution says, and the president is there to faithfully execute those laws. And by the way, when the founders framed this Constitution, what they were afraid of is that there would be power concentrated in the hands of very few people or in the hands of one person. And so what they did is they framed the Constitution so that they included checks and balances with 3 co-equal branches of government, at least co-equal. We are Article 1. But at least co-equal. And that was in order for each branch to have jurisdiction and authority over making sure another branch was not abusing their power, not obstructing justice, not using power for their own purpose instead of for the American people. And so now, if we have one branch saying we are not going to respect the authority of a co-equal branch, that puts us in a very, very dangerous position. And why is it that we want these materials? 100% of the materials, not 92%, not just the chairman with one staff member and then he's not allowed to talk about it to anybody else, but everybody. And the chairman has been very generous. He conceded that it would just be the members of the Judiciary Committee and the Intelligence Committees that would look at the full report, not just the unredacted report, but the underlying evidence. Why is that important? Because we need to see everything that was in the report. And frankly, the Attorney General has misrepresented what is in the report. Just look at these articles, the discrepancy between the Mueller report and Barr's summary, how Barr's excerpts compare to the Mueller report's findings. You know why these articles were written? They were written because Attorney General Barr misrepresented what was in the Mueller report. Here are the words of Mr. Mueller himself. Barr's summary letter did not fully capture the context, nature, and substance of this office's work and conclusions. This threatens to undermine a central purpose for which the department appointed the special counsel, to assure full public confidence in the outcome of these investigations. So that is why we must see the full report, so that we can understand exactly what was in it, we can do our constitutional obligations. And I want to be clear that if the president refuses this request, refuses all subpoenas, refuses all witnesses, that affects every aspect of the American people's lives. It means that there is no oversight when the president seeks to strip health care away from millions of Americans. It means there is no oversight when this administration rips children away from their parents at the border. It means there is no oversight over the utilization of public power in the White House for personal gain. That is why it is incredibly important. And I just want to take on one quick thing. My colleagues keep talking about how crazy it was that we didn't, that we wanted to have staff counsel question the Attorney General for 30 minutes. Let me just read a quote from a member of Congress. The goal of attorneys is to depoliticize the process and get to the truth instead of grandstanding. You know who said that? Senator Chuck Grassley during the Kavanaugh hearings. And did any of my colleagues object at that time to Senator Grassley using an attorney to question the witnesses? No, they did not. I don't see anyone on record having said that. So, Mr. Chairman, let's be clear. We are at a brink of importance between democracy and dictatorship if we ignore checks and balances. And I fully support holding this Attorney General in contempt for refusing to comply with constitutional foundations. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. For what purpose does the gentleman from Florida seek recognition?
I have an amendment at the desk, Mr. Chairman.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with the subpoena duly issued by the Committee on the Judiciary, offered by Mr. Gates of Florida.
Provision shall be construed. Yeah, fine. We will.
After the last paragraph on page 27, insert the following. Rule of construction, no provision in the resolution.
Without objection, the amendment is considered as read. Gentleman is recognized.
Thank you, Mr. Chairman. Earlier today, the gentlelady from Pennsylvania, the vice chair of the committee, said, and I quote, "Nobody is asking the Attorney General to break the law. Nobody is asking the Attorney General to break the law," close quote. And so that comment inspired me to write this amendment, to test the sincerity of that reflection by the leadership of the committee on the majority side. My amendment merely says that no element of the resolution or the report that's currently before the committee would be construed to require the Attorney General of the United States to break any law or break any rule of federal criminal procedure, expressly including but not limited to the rule that has the force of law that says that the Attorney General is not able to provide specific grand jury testimony. And so my hope is that my colleagues were in fact sincere, that this isn't about putting the Attorney General in a catch-22, but I fear that may not be the case. Here's why. If the chairman wanted to, he would be able to go and read the remaining 8% of the Mueller report and in fact take notes on it and potentially even share his thoughts, impressions, conclusions on the House floor. We, in fact, have seen circumstances where the ranking member, in an effort to facilitate greater context and understanding and transparency about the work of this committee over the last few years, has in fact gone to the floor, utilizing the privileges of the House to release transcripts and testimony that shed light on the true origins of this investigation, the true bias that infected the senior levels of the Department of Justice and the FBI. And so if that was what this was really about, my friend from Maryland, my friend from Washington both said, well, 8%, that could be the whole deal. That could be as significant as the freedom of speech and the freedom of press. I mean, we could find things in this 8% of the report that fundamentally reshape our understanding of the Mueller probe. If that's the case, then just do it. Go tell us what's in it. You have the ability to go read it, come back and share with the rest of the Congress and the rest of the country.
Would the gentleman yield?
Well, since my microphone was cut off last week, I'm going to try to use it all of this week when I have the time, so I'm not going to yield. I do think, though, that as we've heard our colleagues wax poetic about the rule of law, it's important to highlight some of their statements. My friend from Rhode Island said, the rule of law questions are deadly serious. Deadly serious, like life or death, these rule of law questions. And so if we are holding up the rule of law as this great virtue, why then would we ask the Attorney General to break the law in order to serve the rule of law? My friend from Washington said this is one of the greatest tests of the committee. This tests our muster and our merit to see whether we will continue this pursuit of the truth. It is my expectation that this is in fact on purpose. That what the majority has tried to do is put the Attorney General in a situation where they can generate conflict. And they need that conflict because they have a narrative of impeachment that currently binds their caucus. I mean, look, with the Democratic Party right now, you got a fundamental problem. You got one group of people who control the levers of power, the Speaker Pelosi's, and the senior leadership of the Democratic Party. And then you got this whole other batch of people who really control the energy of the party that are on this fast march to a factless impeachment. And so they have to go and generate these little skirmishes to keep the hamsters on the hamster wheel so their more rambunctious members won't rush to the floor in search of impeachment. And it's just, let's just be honest that that's why we're doing this. Let's be honest about the fact that you are using the Attorney General of the United States as a whipping boy because you can't go after a popular president who's got a humming economy, who has seen his approval rating rise since the release of the Mueller report. So do us all a favor. Do the rule of law a favor. Provide substantive legislation that reflects on the words your own committee leadership has used in this very meeting. That you will not use this process to impair the rule of law and to ask the Attorney General of the United States to break the law. And if, by the way, if there's nothing in your report or resolution that demands that the Attorney General break the law, vote for it. Vote for my amendment. But you won't, because you know the real purpose of this is to distract the country, create a fictitious conflict, and divide us even further after you were proven to not be telling the truth as a party about the Russian collusion hoax. I think we can do better. I think this amendment clarifies your words, but you won't vote for it because it's not really what you're doing. And I yield back.
Gentleman yields back. I recognize myself for 5 minutes on the amendment. The gentleman's theories about motives and witch hunts and aside, which I don't agree with, obviously, although I do appreciate the gentleman's use of colorful imagery about the hamster and the hamster wheel. It has never been our intention, as we've stated before, to ask the Attorney General to violate the law. We've always intended, and we've made it very clear, that we wanted him to come to court with us to ask for an exemption to Rule 6E. But having said that, the amendment simply restates our intent, and therefore I accept the amendment. I urge my colleagues to support the amendment. Is there any further discussion on the amendment? Hearing none.
Mr. Chairman.
Gentleman from Arizona. For what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I do appreciate that your willingness to support the gentleman from Florida's amendment. I appreciate that. I'm going to also support and vote for that. But I just want to make one thing perfectly clear again, as I iterated before, and it goes to something that the chairman just said, and it gets to the heart of this thing, and that is, if really one were to believe that the underlying contempt citation was issued irrespective of and not designed to put Mr. Barr into a box where he's got a binary choice, effectively saying, I'll either violate the federal law or I will be held in contempt. I just find it somewhat odd and awkward that he was invited then to go to court and appeal to the court and say, give me permission to reveal this redacted information pursuant to Rule 6E. I mean, I just think that's really interesting, because nobody would really say we need to go to court if you didn't believe that you didn't have authority. And that's, so it's obvious to me that maybe people don't believe they have the authority. They feel they need to go to court. And so I think this amendment, and I'm glad the chairman supports it, because I think this amendment clarifies that it's not the intention of this committee, and nor does Mr. Barr, is he obligated to violate the federal rules. And so with that,
Will the gentleman
Mr.
yield?
Chairman, I'll yield back. I'll yield back my time.
Gentleman yields back. For what purpose does the gentlelady from California seek recognition?
To strike the last word.
Gentlelady is recognized.
One of the great principles of legislating is to accept a win. So I'm hoping that we can agree to this and go on to what other further discussions we may have. I would just like to say that, you know, as I listen to the debate, and I've listened carefully, the concept that it would be reasonable for Mr. Collins and Mr. Nadler to be the only one among our members to review this material is astonishing to me. For example, Mr. Sensenbrenner has been a member of Congress since 1979. That he would not have something to offer if he reviewed this is just not correct. I've been a member of this committee since 1995. I would have something, I think, to offer if I were to review this. So I hope that we can get past the idea that what's been accepted, proposed by the department and then withdrawn is an acceptable outcome. And I would yield to the chairman of the committee.
I thank the gentlelady for yielding. I just want to comment on what was said a moment ago by Mr. Buck. As I said, Biggs, I'm sorry, but Mr. Biggs. As I've said repeatedly, and as the record will bear out, the subpoena was never intended to cover Rule 6E. It has always been made clear that we understand that it is unlawful to get grand jury information without permission of the court. That's why we have asked the Attorney General to join us in petitioning the court to get that grand jury material. That is the practice that has been done in many similar situations, in fact, in every similar situation I can think of, in which the Attorney General has gone to court with the committee and gotten the court's permission to use 6E material. We are disappointed that the Attorney General is not doing that, has declined to do that for reasons he won't state. But the contempt citation is for his ignoring the subpoena, in effect. It was never intended to give him to put him in jeopardy by saying you have to give us 6E material. This amendment makes that crystal clear, and we're perfectly happy to accept it since that was always our intent. And there's certainly no contradiction between saying you have to obey a subpoena which is not intended to include 6E material, but by the way, let's ask for the 6E material separately, ask for a court. So I hope that clarifies things. And I urge a yes vote on the amendment. I yield back.
Mr. Chair. Mr. Chairman.
The gentleman from, what purpose is the gentleman from Georgia seeking?
Move strike last word.
Gentleman is recognized. Gentleman is recognized.
Thank you, and I'm glad that the chairman is accepting this, but let's also be clear that this motion is also for the report and for this contempt area that we're asking to now. We actually offered an amendment during the subpoena, which you just referenced very eloquently. You said it didn't require 6E in your subpoena. However, when we offered an amendment to exclude 6E, we voted for that amendment. Y'all rejected that amendment. So it's interesting that it may not, if you're saying now it doesn't include 6E information, but when we specifically offered an amendment to the subpoena that excluded 6E, we voted for that amendment. You rejected that amendment. There's a contradiction in terms. I'm glad we're accepting this. I'm not going to belabor the point. There's other things that we can talk about, as we go forward. But I will yield to the gentleman from Colorado.
I thank the gentleman for yielding, and I also appreciate the chairman accepting this amendment. I am confused, though, and legitimately confused. I'm not trying to make a political point here. My understanding is that the Attorney General's report has redacted classified information, grand jury material, and ongoing investigations. I'm confused at what we are arguing about if we're not arguing about grand jury material.
Would the gentleman yield?
Yeah, absolutely.
We're arguing about, there were 4 categories of material that the Attorney General tells us were redacted. Grand jury material, which we're not concerned with here, as this amendment makes clear. What else? You just mentioned 2 of them. Things that impact other criminal investigations. Things that may cast aspersions on third-party reputations, and what was the third?
Classified information.
And, of course, classified information. Plus, of course, all the underlying material. So we're talking about those 3 categories of material, not including the grand jury material, the other 3, plus the underlying evidence and materials for the report itself. That's what we're talking about. That's what we've always been talking about.
So reclaiming my time, we have access to classified material in a SCIF.
No, we have not been accorded that. That's part of the request. It's part of the subpoena, I should say.
May I yield to the gentleman from Georgia, please?
Reclaiming my time. We've just hit on something. This is exactly why we're too far in this process. And I appreciate the chairman bringing out that was a very enlightening discussion here, because that is the part of working with the DOJ on accommodations. That is exactly what we should be doing here, not rushing to contempt. And I think this is, again, I'll go back to my original point, the 6E information if it wasn't a part of the subpoena, then why reject an amendment that actually said that? And I think that's the curiosity, but I appreciate the chairman, and this is not a criticism, and I agree with my friend from Colorado. This is not a criticism, but this is exactly why, again, for those of us who've been here a while, this is why this contempt is too quick. You can get to attempt at some point.
The gentleman yield?
I'll yield, yes.
We attempted to negotiate, I thank the gentleman for yielding. We attempted to negotiate with the Department of Justice for what, 2 months? Yes. For 2 months, and they refused to talk to us. They finally, only under the threat of this contempt proceeding, were they willing to talk about an accommodation in the last few days.
Yep.
And then, my opinion is their so-called accommodation was not an accommodation at all. But for 2 months, we tried to initiate negotiations with them over the precise things you're talking about, and they refused to talk.
Now, and reclaiming my time, and I think reclaiming the time here, you're exactly right, but even 2 months ago, we were just at the very beginning of a report that just came out. And again, this has been talked about all along, but I think this is a healthy debate right here on exactly what we're talking about. I think the reason that we're concerned, and I'm concerned, and many of us are concerned about the actual move to contempt here, is 2 months when looked at in the prism of just the last little bit in this Congress, and the previous Congresses, the timing here is what we're talking about. And it's been said earlier, and I didn't say this earlier from when some of the been comments on the other side that said that when we get to court, when you go to court on a contempt, a civil contempt, especially like this, is that the judge will look at what accommodations and what process has been made. If we have cases in direct discussion here in which over 400 days were used, 300, these are the kind of things.
Gentleman yield for one sentence.
I'm at this point need to yield back. I want to yield back to Mr. Buck for a second.
Would the gentleman yield for?
He said I'm yielding to Mr.
Would the gentleman yield for
I only
one
have 50 more
sentence?
seconds.
I thank you. I would simply point out that 2 months of refusal to talk to us or to negotiate is not trivial. I yield back.
I never, and Mr. Chairman, I'll take back my time. I'm not saying it's trivial, but it's not nothing. It's not enough either. And I think that's where our terminology is getting. And again, Mr. Chairman, you yourself were very critical of holding Mr. Holder in contempt. Very critical of him being held in contempt. And that was a process that lasted a long time. And my time's over, and I yield back.
Mr. Chairman, I just have a few more questions, if I may, Mr. Chairman, in good faith. Move to strike the last word.
Seek recognition.
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I am wondering what prevents the committee attorneys from going to court and asking the court to disclose grand jury material. We could ask for that waiver ourselves. We don't need the Attorney General's permission.
Gentleman yield for an answer?
Yeah, I would yield.
Nothing. We intend to do exactly that, but the application is greatly strengthened if it is supported by the Attorney General, as opposed to the Attorney General either opposing it, which we don't know he would do, or not supporting it. He has said he would not support it. In every previous case where the committee has gone to court and asked for 60 material, the Attorney General has supported that request. What is new is that he has said he would not support the request, and he's given no reason for that.
And Mr. Chairman, reclaiming my time, I believe that in every single case, at least the ones that you have cited in the past, there was an ongoing impeachment proceeding or a select committee that had been impaneled to hear those issues.
Would the gentleman yield?
Yes.
No, that's not correct. For instance, Ken Starr, the special prosecutor, went to the grand jury went to the court rather for grand jury material well before there was an impeachment inquiry.
And in that situation, we were operating under a different set of rules. There had been a law passed by Congress.
Also, I should add, also in the question of Judge Hastings' impeachment. Well, and let me just say what you just said. Yes, we're operating on a different set of rules, but they do not. But the initial grant of power for the special prosecutor and the special counsel differs, and some other things differ too, but they don't differ in any respect in any way with respect to the ability to get information or with the ability to seek the Attorney General's assistance in going to court to get grand jury information.
But the law that was passed for the independent counsel statute specifically granted Congress the ability to get grand jury material. The regulations...
No, that's incorrect. I'm told that's not true.
Okay. The regulations...
That it granted it at the discretion of the court.
Okay. All right. I just would recommend and ask that if this, that we hold a vote, that this committee authorize the staff to go to the court and ask for grand jury
Well,
material.
we certainly intend to do that. I don't know if we need a vote of the committee to do so. If we do, we'll hold such a vote.
Okay. I think that resolves at least a portion of the...
I don't know that it's a question. We certainly intend to do that.
Okay. I yield back.
The question occurs on the amendment. All in favor of the amendment, say aye. Aye. Opposed? The ayes have it. The amendment is adopted.
I have an amendment at the desk, Mr. Chairman.
We're doing your amendment now.
Okay. I recognize myself for the purpose of offering an amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with the
Without
subpoena.
objection, the amendment will be considered as read. I now recognize myself for the purpose of explaining the amendment. I am introducing this amendment in order to address the last-minute purported claim of executive privilege by the President over the entirety of the material sought by this committee's lawful subpoena. This is a development that just occurred this morning. It is regrettable that this unfounded claim interrupted negotiations that had finally begun after the committee's many requests. The Attorney General and the Department of Justice ignored our repeated attempts at accommodation and compromise for well over a month. Only in the face of a contempt resolution did the Department begin to engage in a discussion of accommodation without producing a single page of the underlying evidence or materials. When that effort failed, the Attorney General took the extraordinary step of asking the President to assert executive privilege in order to conceal the entire special counsel report and all the evidence and materials underlying it. There is no legal right to stonewall or to obstruct legitimate oversight. That is what we have been seeing as a result of the President's declaration that he is, quote, fighting all the subpoenas, unquote, issued by Congress. The Attorney General may believe that he is merely following orders and seeking to prevent Congress from carrying out its constitutional responsibilities. But history has shown time and again that the first line of defense against undemocratic rule is for those individuals asked to carry out indefensible orders to show the courage, independence, and belief in the institutions under attack to just say no, as the President's former counsel, Don McGahn, did on a number of occasions. We are disappointed that the Attorney General has again shown with his actions today that he is not that person. He has left this committee no choice but to reject the baseless, improper, and indefensible blanket assertion of executive privilege and pass this resolution holding him in contempt. I am proud we are taking this action in defense of our great nation's constitutional system of checks and balances, which, make no mistake, is clearly under attack. I am proud of this committee for standing up in defense of our democratic institutions and principles that we hold so dear. I yield back the balance of my time. Who seeks recognition?
I do, Mr. Chairman.
For what purpose does the gentleman seek recognition?
I seek recognition to oppose this amendment.
Gentleman will.
Try the last word.
Recognized.
Thank you. I think we're interesting now going into this and then trying to come up with something that, let's just go back, on some grounded points here. Executive privilege is grounded in the Constitution, for the privileges and waivers must be intentional. What we're trying to do and arguing through your amendment here is argue the executive branch talking to the executive branch is somehow a waiver of executive privilege. Chairman, you say that because the report is public, executive privilege has been waived. You rely on the SB case referred to as in re sealed case. The court that had executive privilege waivers must be intentional. In the SB case, the White House counsel's office conducted an investigation and made the resulting report public. In fact, the court said since executive privilege exists to aid the governmental decision-making process, a waiver should not be lightly inferred. The court had refused to take an all-or-nothing approach to executive privilege. Quoting from the very decision that you're relying upon for this motion, the courts have said that the release of a document only waives the privileges for the document or information specifically released, but not for related materials. Here, all the underlying materials not made public are privileged. This is a balancing test where a crime has occurred in the Nixon case. Here, there is no crime that has occurred in the Mueller, as the Mueller report demonstrated. In Ray Seald's case, the court also said the privilege should not extend to the staff outside the White House and executive branch agencies. Instead, the privilege should apply only to the communications authored or solicited and received by those of the immediate White House advisor staff who have broad and significant responsibilities for investigating and formulating the advice to be given to the President on a particular matter which the communications relate. This is an interesting point and should be pointed out because actually when we had our markup and the subpoenas that were issued were to Annie Donaldson, Don McGahn, Steve Bannon, Hope Hicks, Reince Priebus, the highest ranking officials in this, some of the highest ranking in this White House, and the very people the court held that should have executive privilege. And when we look at this in the underlying report, even in the Mueller report, just getting around it because we don't like it through an amendment is not getting around this. And I think when coupled with the fact that we have had discussions here of rushing to this, not having an accommodation process, not talking, and many times, as you well know, and folks who have been here a while, it does take what I'll call, those termination points, those pinch points. There's not an impasse here. And I think that's the interesting part about this. And it's always talked about in contempt is what is the impasse? There is no impasse here because there's at least still negotiations, even from what the Department of Justice offered yesterday to say if we go to this step, we'll be back next week and we'll discuss some more. There is an impasse. Now, maybe there's the discussion that didn't like it because this was actually, the same thing was done by President Obama in the Eric Holder case, but actually not for those closest to the president himself, but for actually lesser officials. So in looking at this is not new in the exertion of the executive privilege. The case that you're relying upon, even in the most generous reading, is a 50-50 toss-up for what you're trying to do here with this, and that's at the most generous of reading. At a sort of what I would say is a factual reading in it, it's not 50-50. It says that this is actually held. So as we go down this line, I understand the chairman's frustrations. I disagree with the chairman's frustrations on the fact that you're not getting the information that you want, or you're at this point not getting it in the way you want it. But it has been pointed out that you have the ability to go to court to try and make this happen. Also, before I quit here, the Starr case is not precedent, and we keep bringing this up. The Starr case is not precedent. One, the statute is defunct, and also today we have what is the Clinton-era Special Counsel Investigation Regulations, which is what Bill Barr is actually operating under. So if we want to go back and discuss, again, non-applicable precedent here, that is something issue because the Starr report was actually made for the purpose of giving recommendations for impeachment. That's not what has happened under the special counsel's advice here, and was not why the Mueller report was actually done. So if we count this case from a strictly legal reading, again, at best, it's a 50-50 jump ball to say that this is actually for this. But if you actually get into it, and especially what your subpoenas asked for, those closest to the president, this case actually sides and leans more toward what my argument that this case does not apply and that your amendment is not should not be well taken and should be voted down. We have a lot left to go here. There's more problems with this than just the executive privilege issue that has been listed here. There is the problem of once you get before a judge and saying, what did you actually do to ask and get to this? There's no accommodations been made. This is, again, a process and a rush to judgment. I would encourage all members to read the case, read the underlying case that this is based on, and reject this motion as it is offered. And with that, I yield back.
Thank the gentleman. Having used far less than my allotted 5 minutes, and having just realized that in the haste with which we prepared this, I neglected to actually describe what the amendment actually does, I yield myself 15 seconds for that purpose. The amendment supplements the contempt report to address the Attorney General's statement last night and letter this morning that he is asserting executive privilege over the redacted portions of the report and all underlying materials. The amendment also then explains some of the many reasons why we believe that assertion of privilege lacks any valid basis. I yield back. Who seeks recognition? Then we'll take the vote on the gentlelady from Pennsylvania is recognized. For what purpose does the gentlelady from Pennsylvania seek recognition? Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you for offering this amendment, which I support. I was puzzled, maybe like many of you, that we received this morning, I received it here in hand at about 10 o'clock this morning, a letter dated today, May the 8th, 2019, addressed to the President, the White House, Washington, D.C., Dear Mr. President, I am writing to request that you make a proactive assertion of executive privilege with respect to the Department of Justice documents recently subpoenaed by the Committee on Judiciary of the House of Representatives that is signed by William Barr, Attorney General, not personal attorney to the President, Attorney General Barr. And I contrast that with something I was taking a look at, dated January 29th of last year, 2018, written by personal attorney for the President, John Dowd, to Robert Mueller, in response to Robert Mueller asking for the President to come on in and testify, to interview with the President and discuss concerns regarding the report and the investigation. There's a list of some 15 areas of concern that the special counsel asked for the President to come on in and discuss. And guess what his personal attorney, John Dowd, said during this long letter? After reviewing the list of topics you presented, it is abundantly clear to the undersigned that all of the answers to your inquiries are contained in the exhibits and testimony that have already been voluntarily provided to you by the White House and witnesses, all of which clearly show there was no collusion with Russia and that no FBI investigation even could have been obstructed. Farther down in the letter, we all remain in agreement that your office has received unprecedented access and voluntary cooperation in the collection of all documents requested by the White House. It goes on to further say, in an effort to provide complete transparency, the President waived the obviously applicable privileges where appropriate in order to show both the Congress and the special counsel to see all relevant documents. His personal attorney more than a year ago waived the privilege, said everybody came in, they had the right to testify, they had the right to meet, they spoke for hours, whether it was McGahn or any others, Hope Hicks and others. And yet this morning, the Attorney General asked the President, please claim, put a big drape over this thing. Please claim privilege. And then we later got a letter from the Attorney General saying he's claimed privilege. So I guess there was a conversation there. Imagine that. An Attorney General sworn to uphold the oath of his office, to be an independent, highest voice of the law of the land, hanging a heavy drapery of distortion, distraction, and deception over this incredible, important investigation. Mr. Chairman, we are at a grave moment. I thank you for holding this very important hearing on contempt. Our constitutional system of government is in jeopardy. We have to make sure that we protect the rule of law. We are up against an administration that cares nothing for the rule of law, cares only for self, and we need to see the entire Mueller report. Mr. Barr has given away his credibility here. We know that. His letters have no meaning because they do not reflect the truth. And so I stand in support of your amendment and, of course, in support of the underlying contempt report. Thank you, Mr. Chairman.
Gentlelady yields back. For what purpose does the gentleman from North Dakota seek recognition?
Move to strike the last word.
Gentleman is recognized.
I think we have some signals crossed. Until about 30 seconds ago, or 5 minutes ago, or 10 minutes ago, this subpoena was for a full unredacted version of the Mueller report. My colleagues on the other side of the aisle have given speeches, have cited cases, now I don't think they're entirely relevant, about releasing 6E material. We just had a witness, or just had a speech saying we get the entire report. Now we're hearing conversations about 6E isn't necessarily in it, but it's in the subpoena. The subpoena is simple. It is fully to have the unredacted Mueller report. And just in the way that words matter, the letter didn't say a proactive assertion of privilege. It said a protective assertion of privilege. And I think we can reasonably argue that one of the reasons they're doing a protective assertion of privilege is in order to comply with the subpoena, they would have to violate the law. Now, we talk about compelling, or we talk about asking the Attorney General to go to court to release rules or grand jury evidence. We talk about how that has happened in the past. First of all, in the case that had happened in the past, it was actually the Halderman case, and the reason the court ruled in favor of releasing the information is because they heard it was because they ruled that it was a legal proceeding because it was an impeachment proceeding. Secondly, the Attorney General has no obligation to go to court, and by issuing a subpoena, this committee cannot compel him to go to court. This committee can go to court on its own to try and release that information, but by the way, and I'll be offering an amendment later, there's no guarantee that is going to happen either. So when we're having this conversation, when we're giving speeches, when we're going on CNN, when we're going on MSNBC, let's at least talk about what this is about. The subpoena was to release the full unredacted report. And regardless of the colloquy we're having today, regardless of the debate we're having on this dais about that very information, that's what the subpoena says. So when you issue a protective assertion of privilege, you have the right to do that, particularly, I think, if you're the Attorney General and you think you'll have to violate the law in order to comply with the subpoena. Secondly, and I think it becomes interesting and more important when we discuss how this has moved forward and where we're at. And by that, I mean, we're citing the SB case, we're saying that we have all of these different issues, but nothing that has been redacted has been shared. It's only been shared from executive to executive. None of the underlying information has been shared. To say that there isn't a valid claim of assertion of executive privilege on that information, I think I agree with the ranking member, is a jump ball at best. So,
Will the gentleman yield?
With that, yeah, I yield.
Mr. Armstrong, with great respect, I guess the question may be to Ranking Member Collins. You said that executive privilege has not been waived with respect to the redacted portions of the report. Now, I'm not talking about the grand jury piece. I'm talking about the other pieces. My understanding is that the ranking member has seen that unredacted material. Am I mistaken?
I haven't seen it, so.
I know you haven't seen it, Mr. Armstrong, which is why we're here, right? I mean, fundamentally, it's so that the members of this committee, as well as the members, I would say, of the Intelligence Committee, I might add, can have access to those unredacted portions of the report so that we can ultimately do our jobs. And so I just want to clarify that piece.
And the answer, I think, becomes when you go into a contempt proceeding as you're working through this. And I'm confused now as to whether 6E material is part of the subpoena. Actually, I'm not. I know it is part of the subpoena, but it's part of the conversation that has gone on. So asserting protective assertion of privilege, I mean, they have the right to do that. What the ranking member has seen and hasn't seen under those settings, I think, is a completely different conversation. I yield back.
The gentleman yields back. Who seeks recognition? The gentlelady from, for what purpose does the gentlelady from Texas seek recognition? Gentlelady is recognized.
I'd like to thank Mr. Neguse for giving a moment of clarity for the basis of this hearing and this markup, which is to illuminate on the unredacted entirety of the document, unredacted. But I'd like to add just a point or two of clarification. I just want to rhetorically ask the question, if the document was issued during the time frame of 2012 to 2016, it was the previous president, what my friends on the other side of the aisle would be engaged in. There would be no doubt in my mind that they would be raging for the entire report. They would not only subpoena, they might even use inherent powers to attempt to incarcerate some of the administration officials under the Obama administration. We now are working on the basis of our chairman having worked extensively on accommodation. That terminology means that we've been reaching out to the Department of Justice to work with their lawyers to find a common ground to provide the documents that we ask. To clarify the gentleman, Mr. Armstrong's point, we understand the law over here. We understand that the 6E materials are materials that deal with matters that will have to be reviewed by the court. We don't intend to utilize materials randomly. And so we've asked the Attorney General to come to court with us. Of course, these documents are important. because they go to the full understanding of the American people. We know that many of those documents may be held in a classified or confidential manner. We would intend to do that if that was necessary by the court. So to act as if you are confused, the resolution speaks for itself. The unredacted document in its entirety, the supporting materials, documents that Mr. Mueller utilized, and appropriate 6E as dictated by a court proceeding, which we would go and hope would move expeditiously. The reason why this is so important for the courts to look at this seriously is, again, whether you use the word protected or proactive, it is the request for a blanket use of the executive privilege, which, as I said earlier, is historic. Today, on this day, in 2019, you are seeing a request on May 8th for something that has never been requested by any president of the United States, no matter how much review, investigation, and trouble they might be in. So this is historic. And I believe for the very infrastructure of the Constitution, there is no way that we can yield or cede to a blanket request for executive privilege. And I asked a rhetorical question as to what my friends would have done if this same document had come out between 2012 and 2016, and what the American people would have asked us to do. And so I believe we should move on the resolution, the underlying resolution, because we have seen actions that have never been utilized. We have sought an accommodation. We've received letters on May 8th today, both the letter to us indicating that we had breached the accommodation, and the breach came from the Attorney General, not from this committee. We were still negotiating late into the night. That should be very clear. And as well, the seeking of a proactive, protective assertion of the executive privilege. I would offer to say to you, an executive privilege that has been waived. Let's get on with our work in finding out the truth, and let's clarify what Mr. Nadler is asking for. I think he's been very clear, and I certainly think he has been measured in his attempt to work through this with the Attorney General. And I would hope that we would rise to support the resolution, of which I support. I yield back.
Gentlelady yields back. For what purpose does the gentleman from Colorado seek recognition?
Move to strike the last word.
Gentleman is recognized.
I yield my, as such time as the gentleman from Georgia desires.
Thank you, and I appreciate the gentleman yielding. And I agree, and this is one of the things that I've thought about a while, and as I mentioned, it was a very true, sincere. I think we have a lot of good attorneys on this committee. That's why we were, objecting not to have questions. And I would, if my friend from Texas and I were in a courtroom together, my immediate thought as an old trial lawyer would be, objection calls for speculation. You're asking what speculation would be on what we would said, but I don't have to have speculation on this. I have facts. What did happen during the previous administration when a contempt proceeding was going on? They actually did, the DAG actually made the preemptive assertion, Jim Cole actually made the preemptive assertion for the privilege. My friends across the aisle actually disagreed with this, didn't want it to happen, in fact walked out, made a big production saying it was all political and they should have never held Eric Holder in contempt. The interesting part is, and I go back to this, that will actually be repeated and repeated and repeated, is that was over 400 days. We're still under, even at the generous 2 months level here. And I think it's really interesting happening because I want to go back to the, really the interesting issue that Mr. Neguse brought up, which was a valid point. It says something to bring up, but it also strengthened my argument that we're going too quickly, that there were accommodations made. The Department of Justice were in the process of making accommodations, and they made that from the original intent of letting members go. That was never, I never saw a definitive statement that said that's all we'll ever do. Okay, and I did go see it. That was public record. I did go see it. The chairman has not gone and seen it.
Would the gentleman yield?
I will.
Ranking member, with all the respect in the world, while I appreciate that, it seems to me that it's been pretty clear from the Department of Justice that they will only allow you and the chairman of this committee, as well as a few other members of this Congress, of this House, to see the materials you have. Our point is that the Republican members of the Judiciary Committee, as well as the Democratic members of this committee, as well as the Republican and Democratic members of the Intelligence Committee, ought to be able to review these materials to perform their critical constitutional duties. And that's why the ranking member of the Intelligence Committee, Devin Nunes, joined with the chairman of the Intelligence Committee, Adam Schiff, in making the same request that this committee has made.
Yeah, reclaiming my time, and I appreciate the gentleman there, and I think this is the exact thing. That was the request actually was made yesterday. Is we'll have this request. There's never been a definitive. We'll never do because we've actually seen a request or an offer made yesterday that was rejected, and that's why we're here today. That's part of negotiations. As anyone who's went through a negotiation process, that's part of the negotiation. You may not like the timing, you may not like it, but again, in less than 40 days, it's pretty interesting when we had 400 days and over 300 days with Holder and then also with Myers and Bolton. Again, I think we're conflating the issues here, and it's really interesting. The 6E information, we don't need to gloss over that. If you're watching and you're seeing this, don't gloss over the fact that we previously in this committee, the majority rejected an amendment that said 6E information is not going to be a part of this, because now we're looking at this information, and it's been said several times, what is the relevant and what are the speculation and where we go from. I go back to a statement that I made just the other day when the chairman and I were talking about another amendment, and it goes back to this, and this is just true. We vote on words on paper, not intent. We vote on words on paper, and what words on paper say matter, and intent is one that it may intend that we don't ask for this. We may intend that we don't want to do this, but that's not what we vote on in this Congress.
Would the gentleman yield?
I'll yield to the gentlelady.
I thank the gentleman. We certainly could be in the courtroom. I just want to clarify that Mr. Holder's activities were far more distinctive for the actual acts of the President of the United States. We are dealing with the actual acts of a President of the United States. And what I was saying, if that occurred between 2012 and 2016, you would be, my good friends, rushing toward a particular procedure. Yeah, this has to do with actual acts of the presidency. I yield back to you.
And I reclaim my time, and that is exactly what I believe my friends and as my friends have said, you are rushing toward. But I'll also go back to this amendment to the gentlelady. This amendment is actually based on a case, and as I laid that out very clearly, this case is when you look at it even from the Holder perspective, wouldn't even apply there. This is actually the SB case we go forward. Again, I think this all goes into the very assumption that this is why we need, why this is rushed. That's why we've said this all along, and it just goes back to the court, because if taken to court, if my friends take this to contempt to court, if that's what they're intending to do, they're going to look at the record that was laid. And right now, that record and cupboard is bare. With that, I yield back to the gentleman from Colorado.
And Mr. Chairman. Mr. Colorado has the time.
I yield back.
Gentleman yields back. For what purposes the gentleman from, the gentlelady from, for what purposes the gentlelady from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
I think it's so important for us to come back to why we're here and to understand why there's so many efforts to prevent us from getting to the full truth. Let's remember what we all know. We all know that Russia, a foreign adversary, attacked our country, and they did that by meddling in our elections. We know that a campaign, the president's campaign, knew about that attack. We know that they welcomed that attack. We know that they tried to prevent others from knowing about that attack. We know that they made false statements about the attack. And after everyone knew, the president then tried to obstruct the investigation about that attack. And the other thing that we know, and this is what we have to remember as Americans, they are still at it. They were wildly successful in trying to get inside of our elections, wildly successful, and they are still at it. That's why we are here. That's why we are trying to get to the truth. That's why we are fighting so hard for the American public to have access to everything. It's not that complicated. It's actually pretty simple. But I'll tell you, I'm new here, and earlier one of my colleagues, Ms. Scanlon, said she's also new, how this whole thing really saddens her. And Mary Gay, it saddens me too. I can't believe this. I cannot believe this. Something that should be unifying Republicans and Democrats alike, fighting for this country, fighting for the integrity of our democracy, fighting for our elections, fighting for the American people. But instead, this is what we get. We get different ways and avenues and strategies to obstruct getting to the full truth. I want to remind everyone here, and I want to remind the American public about the oath that we took. We took an oath the day we were sworn in to support and defend the Constitution of the United States against all enemies, foreign and domestic. Further, that we will bear true faith and allegiance to the same. I remember my oath. I take my oath seriously. And all of these efforts to create obstacles and roadblocks to getting to the full truth, shame, 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 shame. Mr. Chairman, I support your amendment. I support this resolution. And it's about time that everyone unite and fight for the American public.
The gentlelady yield.
I do. I yield.
Yes, we simply do not have 400 days to wait before making sure that we are protected in the 2020 election. We know that in 2016, the Russians interfered with our election so that they could help Donald Trump get elected. Donald Trump will stand for election, re-election again, in a very short period of time, and we don't have 400 days to wait to determine whether or not we are in shape to withstand any additional attempts for the Russians to try to interfere to help Trump get reelected. And I don't want the public to be confused. 6E is not the issue here. We know that we have to get with the courts in order to obtain grand jury information. We know that, and we're prepared to do that. Ordinarily, the Attorney General would go with us to court to do that, but he doesn't want to do that. But the other three things that they are withholding information from, they are redacting the Mueller report for, are for ongoing matters. They don't say ongoing investigations or prosecutions, ongoing matters. What does that mean? National security, sources and methods. We can deal with that. And then the third thing, embarrassing information on peripheral third parties not charged. Those are things that we need to be negotiating about, and this administration has refused to do so, and that's what this contempt proceeding is all about. And with that, I yield back.
I yield back my time.
Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stube? Mr. Stube votes no.
Has every member voted that wishes to vote? The gentlelady from Washington?
Ms. Jayapal votes aye.
The gentleman from Tennessee?
Mr. Cohen votes aye.
The gentlelady from Arizona?
Ms. Lesko, you are not recorded. Ms. Lesko votes no.
Are there any other members of the committee who have not been recorded who wish to be recorded? The clerk will report.
Mr. Chairman, there are 20 ayes and 12 noes.
The ayes have it. The amendment is agreed to. There are votes about to be called on the floor at 1:30. It is now 1:31. They should be called momentarily. The committee will stand in recess until 2:30. That should give members time to get a little quick lunch, too. The committee will stand in recess until 2:30.
Yeah.
The committee will come back to order. Are there any further amendments? Gentleman from, for what purpose does the gentleman from Colorado seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a
Thank you.
substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary, offered by Mr. Buck of Colorado.
The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Congress does its work mindful of House and committee precedents. What members have done and said in past instances involving the investigation of a sitting president, appointment of a special and independent counsel, review of a report from the office of an independent or special counsel, and how we review and consider obstruction of justice and ultimately impeachment are all relevant to our work today. Mr. Chairman, as you are well aware, the referral of the Starr report to Congress in 1998 and this committee's consideration of that report in 1998 and 1999 are very relevant to us today. The purpose of today's markup is to ostensibly to conduct oversight, and the insistence of the Attorney General to refuse to violate the law by surrendering an unredacted copy of the special counsel report has led us to considering a contempt of Congress resolution. What is a special counsel report? Is it definitive in its conclusions? Does it reflect one side's views? Is it potentially biased? Mr. Chairman, you said in 1998 that a report of this kind is, quote, a prosecutor's report. By its nature, it's a one-sided report, end of quote. Why then is it so important for this committee to see the unredacted report if it only tells one side of the story? Wouldn't this committee be better off doing our investigation so we can see information that is not one-sided, but instead balanced? Is it critical for Congress or this committee to review 6E materials? There was a time 20 years ago where you suggested grand jury materials were unverified and may not be true and could be salacious. You said their release would be unfair. Why are we interested now in untrue and salacious materials? You said certain grand jury materials must not be seen at all. Given your position, I offered an amendment several weeks ago to protect those materials, and the Democrats on this committee objected and voted against my amendment. Should this committee see the materials on the floor of the House in 1998, you said it would be, quote, grossly unfair to allow members of the Judiciary Committee to see the materials in relation to a report involving obstruction of justice by a Democratic president. In 1998, you criticized members of the Judiciary Committee, suggesting members of this committee would leak the materials. I would note that during the Nixon impeachment proceedings, this committee adopted rules of procedure to protect against leaks. We could do that today, but I would note for the record we have not. Mr. Chairman, in 1999, the New York Times wrote a glowing piece on your opposition to the Clinton impeachment matter. In that article, they wrote that, quote, Mr. Nadler said he was not convinced that Mr. Clinton committed perjury or obstructed justice, but if the president did, the offenses, meaning perjury and obstruction, would not be impeachable, end of quote. So there we have it. Mr. Mueller said no collusion, no provable obstruction, but even now, we have issues that would not be impeachable if they were found to be verified. And Mr. Chairman, I would note that you did suggest in 1999 that impeachment was a, quote, partisan coup d'etat. I believe it is important for this committee to understand and be mindful of its history as we consider today's business. Your past statements related to these issues are as important today as they were in 1998 and 1999. I urge the committee to adopt the amendment to ensure that the report accurately reflects our past positions. I give back my time.
I thank the gentleman for yielding. I yield myself 5 minutes in opposition to the amendment. The amendment incompletely, I should say, mischaracterizes my position of 20 years ago. It mischaracterizes and incomplete also my position today. I, in any event, reserve the right to learn over a 20-year period. I am not going to waste time debating my view in 1998, and I have already stated my views on this matter today. We ought to be focused now on getting the unredacted Mueller report and the underlying evidence for the committee and for the American people. They are of great moment. I'll simply say one thing with respect to what the gentleman said a moment ago. Yes, a prosecutor's report is a prosecutor's report and is not necessarily totally objective. And yes, we should look at other evidence too, but that's where you start. We have to start by looking at the Mueller report and the underlying evidence for it. It's not where we should finish. No one is suggesting that that's the only evidence before us, but it is the start of the evidence. It is essential to the evidence. And as I said, I'm not going to debate my views of 20 years ago, not now. I'll be happy to do it in other forums. I've already stated my position today. I oppose the amendment. I urge my colleagues to vote against it. And I urge my colleagues to do what we can to get the unredacted Mueller report and the underlying evidence for the committee and for the American people so that we can do our job of holding the administration accountable. I yield back. The question occurs, for what purpose does the gentlelady from Florida seek recognition?
Move to strike the last word.
Gentlelady's recognized for 5 minutes.
Mr. Chairman, I wish to speak in opposition to the gentleman from Colorado's amendment. As a former law enforcement officer, I frequently make statements and comments about law enforcement and the Department of Justice. And overwhelmingly, most of my comments are filled with pride and appreciation for the men and women of a profession that I have loved. But Attorney General Barr has betrayed his oath to uphold the law and defend the Constitution. And today, we are voting to hold him accountable for refusing to respond to a lawful subpoena. And Mr. Chairman, we have more than enough reason to be here and to take this action. The special counsel's report documents a pattern of criminal and corrupt behavior and makes it clear that it is not, if it were not for the Department of Justice rule, had the subject of this investigation been any other person, any other man or woman, he or she would have been charged. And shockingly, the report shows the president tried to limit the investigation, fired the investigators, and hide conclusions. Let us also remember that several of the president's associates who were closely related to either the administration or the campaign are guilty of federal crimes. The President of the United States encouraged his associates to hide the truth, illegally suggested that he would pardon witnesses and threaten them with retribution if they didn't protect him. In short, the special counsel's report tells a shocking story of corruption and obstruction. The Mueller report shows motive and means. It documents statements, events, and evidence. However, 48 short hours after receiving the 448-page report from the special counsel, Attorney General Barr rushed to release a letter designed to mislead the nation, knowing that the American people are just busy trying to make a living, take care of their families, trying to stay healthy and be safe. The Attorney General's letter, in fact, was so misleading that the special counsel wrote to the Attorney General saying that the letter did not fully capture the context, nature, and substance of the report, and in fact threatened to undermine the investigation. As a former police chief, a law enforcement officer, someone who worked as a detective and a detective sergeant, I am not angry, I am not ticked off or afraid, but I am deeply disappointed by the top cops of this nation's behavior. Too often, the powerful exploit our system and take advantage of the system and everyone else. But Mr. Chairman, not today. So I do not support the gentleman from Colorado's amendment, but I do fully support the underlying resolution to hold the Attorney General like we would anybody else, excluding the President, accountable and hold them in contempt. Thank you, Mr. Chairman, and with that, I yield back.
Gentleman from California.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman is recognized.
Thank you. First of all, I want to welcome my constituents who have come all the way from Orange County to be here to witness democracy, to witness the Judiciary Committee. Good debate on the law, good debate on policy. And I wanted to take a few moments just to let you know what this is all about today. A lot of debate, a lot of discussion, but this is really about that concept that no one is above the law. And we in Congress have the responsibility on behalf of the American people to hold each and every person accountable for their actions and wrongdoing. Congressional oversight. Congressional oversight is what this is about today. Our democratic constitutional systems of checks and balances says that we have to have meaningful, significant congressional oversight. And today, we're debating simply one important thing, which is access by Congress of the Mueller report. Full Mueller report and all the underlying evidence. We're Congress people. Every day, we are subject, we review top secret documents. Believe it or not, we can keep secrets. And today is one of those days when we have to make sure that we have access to all the information. The Mueller report, Mr. Mueller, everybody seems to have an opinion of what the Mueller report is about, including Mr. Mueller, who came back and said that Mr. Barr's 4-page statement was not correct. So here we are today, asking to see the full Mueller report. And it's just not about what happened in 2016, and that's not about who did what, when, and how. Sadly, it's about something equally important, which is the 2020 election. I also sit on Homeland Security. The former head of Homeland Security, Secretary Nielsen, before she resigned, she tried to tell the president that the Russians were at it again. And the president did not want to listen. If we are to have significant democracy in this country, we have to make sure that we protect it from foreign interference. And today, getting to the bottom of that Mueller report is the first step in the direction of protecting America, protecting our democracy, and making sure that people in this country are assured that their votes and their elections are sacred. Mr. Chairman, I yield.
For what purpose does the gentlelady from Texas seek recognition?
To say the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. And first of all, I want to thank you for your patience and for your judicious demeanor throughout these proceedings and in working with the Department of Justice to reach an accommodation. I find it very difficult to even bring to words what I need to say today because as a lawyer, a former judge, and an officer of the court, I'm astoundingly and profoundly disturbed that the Attorney General of the United States is refusing to comply with a congressional subpoena. Never in my dreams growing up, working hard to get an education with a belief in truth, justice, and the American dream, never would I have believed that I'd be sitting here today talking about an Attorney General of the United States, the top law enforcement officer, refusing to comply with a subpoena of the United States Congress. And what's this fight really all about? This is the report itself for those watching from TV. And it may sound like it's not a lot when they keep saying that it's only 8% of a report, but wouldn't all of us like to hide 8% of our lives? As stated earlier, what about the truth we tell? I'm Catholic. When I go to confession, do I just not tell 8% of the things that I really should confess about? No, you confess about the whole thing. This is what it looks like. If you're the reader, you really do kind of feel cheated because you're reading and then all of a sudden there's just dark spaces. And that's really how I do feel. I feel like I'm being cheated. I feel like The American people are being cheated. So it's important, Mr. Chairman and my colleagues, that we tell the American people exactly why we are here. We're not here because we enjoy yelling at each other or fighting with each other, or frankly, sometimes because we enjoy being with each other. We are here convened today to fulfill our constitutional oversight responsibilities. That, I might add, in addition to legislative responsibilities. The Constitution establishes Congress and the executive as co-equal branches designed to check each other. That system relies on each branch respecting, and I'm going to underscore, respecting the powers of the other two. This committee has issued a subpoena directed the Attorney General to produce an unredacted copy of the Mueller report so that we can see, frankly, what they're trying to hide. We need the full report, but the Attorney General has refused to comply and now belatedly has urged the President to exert executive privilege. In Texas, we say he's a day late and a dollar short. That refusal undermines our constitutional order and its system of checks and balances. And if we do not hold the Attorney General in contempt for this refusal, then it blesses the continued diminishment of Congress as an institution and continues a disrespect to the American people. Congress is constitutionally entitled to the full Mueller report, and it requires this evidence so that we can fulfill our legislative, oversight, and constitutional responsibilities. Mr. Barr may need reminding that no one, not myself, not the President, and not the Attorney General, is above the law. So I therefore think that, Mr. Chairman, that we have no choice but to hold Mr. Barr accountable, and the way we do that is through contempt. I don't support this amendment. I think we need to move on. I don't think it adds anything, and I intend to vote for your motion and your report. Thank you, Mr. Chairman. I yield back.
Chairman.
Mr. Chairman.
What purpose is the gentleman from Wisconsin seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, we've had a number of speakers in a row on the other side of the aisle, and every one of them has forgotten the background of Attorney General Barr, former Deputy Attorney General Rosenstein, and also Mr. Mueller. All of them are prosecutors. All of them are trained to spot where there is enough evidence to obtain a conviction should they go to a grand jury and bring a defendant to trial. In terms of the alleged Russian collusion, there is extensive evidence in the Mueller report that, yes, the Russians did attempt to influence the election, but there was no collusion or no conspiracy. You know, they did things like paying Facebook to have pop-up ads on people's cell phones and other types of things, including getting the voter registration rolls in the state of Illinois and perhaps elsewhere. But there wasn't the tie that they concluded with the Trump campaign, or for that matter, anybody else to do that. Now, in regards to Volume 2 of the Mueller report, again, Mueller is a trained prosecutor. Many of the indictments that he brought were for federal crimes of people who were involved in the Trump campaign, like Mr. Manafort, but for offenses that they committed before Mr. Trump even announced his candidacy for President of the United States. So we're not talking about corruption during the campaign. We're talking about corrupt individuals doing corrupt things before Trump announced and before the campaign started. We hear an awful lot about the summary of the Mueller report that Attorney General Barr made public a couple of days after the report was delivered. Now, first of all, you can read that report in a couple of days. It's 400 pages long. So having a reaction to the report within 2 days is not simply blowing off what may have been contained in there. But Mr. Barr is entitled to his opinions. And what was contained in that letter are the opinions of the Attorney General of the United States, no more, no less, on what he had read in the Mueller report. Now, if Mr. Mueller has a different opinion, and apparently he does from my reading of the press, maybe he should have made that part of the report a little bit more specific so that there would be no ambiguity involved in what Mr. Mueller was driving at. Now, we talk about separation of powers here, and I've heard that repeatedly today on the other side of the aisle. One of the things in separation of powers is that the legislative branch does not prosecute anybody. That's a bill of attainder, and that was specifically prohibited in the Constitution simply because of the excesses of the British Parliament that occurred before the Constitution was written and before the independence of our country. So we don't prosecute anybody. Sure, we do oversight, but I can say there's a way not to do oversight, and that's what we're seeing on the other side of the aisle. I was the chairman of this committee for 6 years in the last decade, and before that I was the chairman of the Science Committee. We did very vigorous oversight on the Patriot Act, as the gentleman from New York recognized. So I did vigorous oversight of our involvement with the Russians in terms of the space station, as those who were around here at that time recognized. But in 10 years as a committee chairman, I never issued a subpoena. And the reason I never issued a subpoena is that I was able to get the information the committee needed to do its oversight simply by negotiating, by writing letters to the agency head, some of which I admit used some very tart language, but at least I was able to get the information that the committee needed to make the agencies operate better without issuing a subpoena. What we're seeing here is subpoena first and then figure out, what we can do to make people embarrassed because they cannot comply with all parts of the subpoena. Mr. Barr can't do that under Rule 6E. So the chairman has put the Attorney General between a rock and a hard place. Comply with a subpoena, you violate the law on grand jury secrecy, blow off the subpoena, and you end up being found in contempt. That's not fair, and it doesn't do this committee any good in getting to the bottom of this. I yield back.
Mr. Chairman. What purpose does the gentlelady from Georgia seek recognition?
Thank you, Mr. Chairman. I'd like to move to strike the last word.
Gentlelady is recognized.
Thank you. On the heels of my esteemed colleague from Texas, I'd like to kind of take a few moments and just bring these discussions back to our broader problem. Today, the House Judiciary Committee is holding a vote on whether to hold Mr. Barr in contempt. And trust me, I take no joy in doing this whatsoever, and I'm disappointed that it's come to this. But compliance with congressional oversight is simply not an option. The American people should be able to know if the government is working for the people. And my constituents in my district, they deserve to know the truth. And this committee, we deserve to know the truth. And we should do whatever it takes to ensure that our government is by the people and for the people. This administration has announced a dangerous blanket policy of refusing to comply with critical congressional oversight. This makes it impossible for us and this committee to fulfill our constitutional responsibilities. And lastly, I'd like to say this. If this committee, with every fiber of their being, is not fighting for the American people, then who are we fighting for? And I yield back the balance of my time.
Mr. Chairman.
Mr. Chairman. For what purpose does the gentleman from Louisiana seek recognition?
Move to strike the last word.
The last word is duly struck, and the gentleman is recognized.
Thank you, Mr. Chairman. I have a point of clarification. It's a bit technical, but I do believe it's very important for the proceedings today. Before we recess, the committee voted unanimously to adopt an amendment by Mr. Gates that provided that nothing in the resolution shall require the Attorney General to break the law in complying with the subpoena. And a number of Democrats, including you, assured the committee your intent was not to force the Attorney General to disclose 6E material, which would, of course, be in violation of the law.
Without a court order.
Without a court order. So on April 3rd, this is the question, Mr. Buck offered an amendment to specifically exclude 6E material from the subpoena. And I have the amendment right here, and I'd ask unanimous consent to include that in the record.
Without objection.
Every Democrat voted against that amendment, and I have the vote tally right here as well, and I'd ask to include that in the record as well.
Without objection.
The amendment failed by a party line vote, 16 Republican yeas and 24 Democrat nays. This morning's vote changes nothing about the subpoena and the demands that are put on the Attorney General. The subpoena, as it stands today, requires the Attorney General to break the law to be fully compliant. If you look at it on its face, that's beyond dispute. I know that, and you know that, and yet you are nonetheless rushing to hold him in contempt. So despite your intent that the subpoena not require 6E material without a court order, that's what the subpoena you issued actually demands, if you read it on its face. You and every single Democrat member on this dais voted for that, and that's the danger that we're talking about today of moving forward so quickly on these things. So here's the question. I ask my good friends and colleagues on the other side, how do you explain today's sudden change of heart? Is it true that it is not your intent to force the AG to break the law by forcing him with your subpoena to disclose 6E material? And if that is your intent, that proves what every Republican on this dais has been saying all day. If it's not, then the subpoena you've issued is dangerously overbroad, and the question is, are you going to reissue a new subpoena? It's a change of heart that I think there's some clarification. I'll yield.
No, we're not going to issue a new subpoena. We have no intention and never had any intention of trying to force the Attorney General or anyone else to give us 6E material without going to court. We did want to, and we still do, want to follow the procedure that has been done in every similar case in the past of going to court, which we will do, to ask for 6E material and having the Attorney General go with us. The reason that was in the subpoena was to increase our clout in court in getting the 6E material, hopefully with the Attorney General's support, but in no way meant to force him to give that support.
Mr. Chairman, reclaim my time. The way I understand it, the Attorney General would be required to go to court to avoid the way the subpoena is written right now. Well, he would be required to go to court.
Yield.
I will yield. Yes, sir.
The subpoena is written as the beginning of a dialogue process, as the beginning of a process to talk to the Attorney General and to the Department of Justice, and ultimately to go to court. But it's designed to be the foundation of a dialogue and is not designed to force our hand in what we insist on in court.
Mr. Chairman, the beginning of a dialogue, let me yield to Mr. Buck, if I may. Mr. Chairman.
Let me just point out.
Well, wait, this is my time, Mr.
We have accepted the amendment today. We've stated the intent. I think that should take care of the matter. Go ahead.
This is a contempt proceeding. Let me yield to Mr. Buck.
Mr. Chairman, I've issued many subpoenas or requested the court to issue many subpoenas on behalf of prosecutors' offices that I've worked in. I've never considered it the beginning of a dialogue. I've considered it a command by the court to produce documents. We are now in a contempt proceeding, and I'm not sure whether you consider this the middle of a dialogue or the mid-beginning of a dialogue, but I consider this a pretty serious matter, as is issuing a subpoena from the Judiciary Committee. If it was a dialogue that you were interested in, and I understand that it's your position that you had attempted a dialogue for 2 months before the Department of Justice came to the table, but if it's a dialogue you're interested in, I believe there are other methods of going about that than a command from Congress to the administration to supply documents. And this is a far, far cry from anything other than one of the most serious matters that we will handle in the Judiciary Committee in the year 2019. So I would ask, and I thank the gentleman for yielding to me, but I would ask you to clarify exactly what we're doing here in contempt, if this is part of a dialogue with the Attorney General.
And Mr. Chairman, just reclaiming my 6 seconds that I have left, in the letter this morning from the Department of Justice to you, he says, you've terminated our ongoing negotiations and abandoned the accommodation process. That's a dialogue. Why did you do this, and why are we here if this is part of the dialogue? We didn't terminate. They did by refusing to make any offer in good faith.
The gentlelady from Florida is recognized. For what purpose does the gentlelady from Florida seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
I think we need to regroup for just 1 second, and I'd like to share my story. I did not have the privilege of being born into this country. I became an American citizen when I was 20 years old, and both when I became a citizen and when I was sworn into Congress, I took an oath to protect and defend the Constitution against all enemies, foreign and domestic. And just last month, I spoke to a group of new citizens in my district in Miami who took that same oath. The room was in tears at the significance of becoming members of our shining example of democracy. Attorney General Barr took that same oath, but now he shows us that the only oath he's following is to protect and defend this president, who right now is threatening the strength of our democracy. Having come from South America, I understand very well what it means when authoritarian leaders believe that they are above the law. They start circumventing other branches of government and consolidate their own power to the detriment of the democratic ideals and freedoms of this country. And we cannot allow this to happen in the United States of America. We have a crisis in our hands. On the one hand, we have a report that details a systematic attack on our election system by a foreign adversary. On the other, we have an administration that refuses to acknowledge these attacks and fails to recognize the Article I powers of a co-equal branch of government. And we have an Attorney General who refuses to comply with a duly issued legitimate congressional subpoena. Now, just for one moment, I'd like to bring up some facts. The Mueller report concludes that the Russian government interfered in the 2016 presidential election in sweeping and systematic fashion. The report states that the Russians attacked our election systems, at least in part to support the Trump campaign. The Russians targeted our state and local governments. In fact, my own state of Florida, including my very own district, Florida 26, was a victim of Russian attacks. The report says that the Russian government sent spear phishing emails to over 120 email accounts used by Florida county officials responsible for administering the 2016 election. And despite this clear threat to our democracy, the Attorney General has seemingly relinquished the duties he owes to the American people. He has chosen to work as the president's personal defense counsel, seeking to bury Mueller's very detailed accounts of the president's attempts to obstruct justice. Since Mueller issued his report, Mr. Barr's conduct has been misleading and deceptive. He's tarnished his own reputation. Despite numerous reasonable requests from the House and this committee, the Attorney General has refused to put the interests of the American people first. He has refused to allow Congress to view the full report and the evidence on which it is based. And now, just this morning, he's pleading the president to assert executive privilege only when the possibility of contempt is on the table. I was elected into office to lower healthcare costs, fix a broken immigration system, pass common sense gun reform laws. But I was also elected to take an oath to defend the Constitution of the United States. I take my job very seriously. And being a mom, I can assure you that I can do more than one thing at a time. In addition to passing legislation for the people, Congress also has a duty to perform our oversight function to make sure that this administration is taking adequate steps to protect our elections from future attacks. And we can't do that job with an administration that obstructs our constitutional responsibility at every single turn. This contempt citation is necessary to ensure that the Attorney General does not violate his oath to uphold the Constitution and is held accountable to Congress and to the American people. I ask my Republican colleagues across the aisle who speak so strongly against the violations of democratic values and freedoms in Venezuela, in Cuba, to not abdicate their Article I powers to this president. Our Constitution, the separation of powers, and our very democracy depend upon us to support and defend the Constitution of the United States and faithfully discharge the duties of our office. I yield the rest of my time.
Mr. Chairman.
I was
For what purpose does the gentleman from Georgia seek recognition?
Strike last word.
Gentleman is recognized.
Okay. Continuing this out, and I know that I'm going to yield to some of our members as well, but it's not an empty point. And I think this is the concern that has been brought up, because I've said it before in this committee, that we don't vote on intent. We don't vote on what we say, and we don't even vote on our words. We vote on words on paper. A judge, anybody else would vote on what's presented to them in court. And the subpoena that I have before me says that the Honorable William P. Barr, Attorney General, will command to appear and identifies certain things to produce. Those things that he was supposed to produce are, number one, the complete and unredacted version of the report submitted on or about March 22nd, 2019. And it says includes but not limited to summaries and tendencies, all documents referenced in the report, and all documents obtained through that. There's no qualification there. It says you will produce everything that we just said with no qualifications of 6E. And if everything is involved there is 6E information in there. So this is something that when you look at when the court would look at this, and if you even look to the back, article on 15 under, I think it's, report number 15 on definitions, 15 says the report means the complete and unredacted version of the report submitted on or about March 22nd, 2019. We had offered an amendment that said that would have excluded 6E information from this report and from this subpoena. That is not in this subpoena. The four corners of this subpoena simply say, give us the whole report. It doesn't say nothing that's not against the law. And it can't be assumed when you put this in here. So as we look at this is an important point. And also there's been a couple of cases where it says, as in other cases, and some of you, Mr. Chairman, you've said this and others, that as in other cases where we go with the Attorney General to make this happen, there is no other cases. The independent counsel case that you cite and others was done under the independent counsel statute, which the independent counsel went to the court to get the information, not the Attorney General. So as we look at this, it's not Mr. Johnson brings up a very valid point. And when we rejected the 6E amendment to the subpoena, this is now what we are left with a subpoena that truly does, on any valid reading of this, that says, if you read this subpoena, any attorney, any judge, it says, give me the whole report. I don't care, even classified. I mean, it's all, you got to have everything here. So this is just the four-corner document of what a judge would look at when enforcing this subpoena. So it does matter. It's not irrelevant. It is a valid question. If we had rejected an amendment on 6E, how do we go, how else then do you say that it's not, except we take your word for it? And around this place, neither side takes our word for it. You go on what's on the paper. Mr. Biggs. I yield to the gentleman from Arizona.
Thank you, Mr. Collins. I appreciate that. The point I wanted to make is real simple. It's getting back to what's going to happen when the court gets there. The court will look at documents. The court is going to look first at the document which talks about a full and complete unredacted, it's going to look at the subpoena which says a full and complete unredacted report. And the point has been made by Mr. Johnson. It's also been made by Mr. Buck and Mr. Collins. That is what will be questioned. Mr. Barr, did you submit to that report, to that subpoena? And there's no way he can comply with the subpoena because we have not qualified it, which puts him back to what I kept saying this morning, is that you've placed him by the terms of the subpoena in an untenable position. It's either be held in contempt or violate the federal law. And so when we move there, the judge is going to say, and since we've now basically qualified the contempt motion that we're here marking up, the judge is going to say, the subpoena you have is now invalid. Your contempt citation is premature. You did not give Mr. Barr an opportunity to respond to the modifications that you made in your contempt hearing. That's what this is about. So when people start talking about rule of law, and we need to do that, and I am all for the rule of law. By modifying today, saying what Mr. Barr has to comply with, you have unalterably changed this subpoena. You're premature on the subpoena that is outstanding. There is no subpoena that's been modified. It is only your motion that has been modified. How in the world will the court rule in favor of you? It's a legalistic argument, but the reality is that's exactly what a judge is going to be asking you. And I yield back to Mr. Collins.
And I think, gentleman from Arizona, again, this goes back to the whole argument we've had on why are we here today? Is it too quick? Have we come to this point too quick? Have we reached an impasse? Today, we've, in essence, and I think it couldn't be construed maybe too broadly here, we've actually made an offer here at this committee today on the contempt hearing. So with that, I yield back. Thank you, Mr. Chairman.
For what purpose does the gentleman from Colorado rise?
Move to strike the last word.
Gentleman is recognized.
Mr. Chair, I'm happy to recognize you for a moment if you'd like to respond to the ranking member.
Let me just, I thank the gentleman for yielding. I just want to say the following. We've been beating a dead horse. We've made clear, two comments. The Constitution requires that the two branches of government engage in an accommodations process when one wants information from the other. I asked the department to begin that dialogue with us long before the report was released, in anticipation of our needs, long before the Mueller report was released. I issued a subpoena only when the Attorney General made clear that he would not provide it to us in any meaningful way. I asked to negotiate with the department at least 5 times over 6 weeks. They provided us with nothing. When we moved to contempt only after the AG blew through our May 1st deadline. I am still willing to reach an accommodation. Late last night, we were still negotiating when the department pulled the plug and declared its intent to declare privilege over all of the material that we wanted, over all the material from the grand jury material, both the grand jury material and other redactions, and all of the underlying evidence. And yes, absent an accommodation, the Attorney General must comply with the lawful subpoena. That is the general thing. Yeah, I heard that with Holder they negotiated for 400, it took 400 days, but the Holder supplied many documents throughout that period. In the end, there was an impasse. Here, they refused to negotiate with us or to deal with us in any way or to give us a single piece of paper. Secondly, we keep talking about the 6E material. We've made clear that the 6E material is not included for purposes of the subpoena, and if it wasn't clear enough, when we accepted Mr. Gates's amendment, that is made super clear. Now, we hope to continue negotiations anyway, but you're beating a dead horse. That is not relevant because A, no one's going to insist on it, and B, the amendment to the contempt motion makes that very clear. I think the gentleman, I yield back. I give time back to Mr. Neguse.
Would the gentleman yield?
Thank you, Mr. Chair.
It's his time.
I know, and that's what I'm asking. Will the gentleman from Colorado
I'll yield for a moment to the ranking member.
Okay, thank you. Again, I get it. If they were wanting to discuss this, it's not happening. But there's no, I mean, how many lawyers walk into a court today and present a 4-corner document to a judge, and then you try to argue, well, that's not what we meant, Your Honor. I meant to actually exclude this, but I didn't have it. I've lost cases that way because I didn't put what I wanted in there. We can't say it doesn't matter. So I appreciate the gentleman yielding here just to make that clarification. It does matter what's in the subpoena. It does matter. And my question is really from a legal perspective, by adding this to contempt today, did we in essence, did the majority of us make an offer to the Department of Justice? I yield back to the gentleman. Thank you.
Thank you. Mr. Chair, I just, again, want to, as I imagine we're getting fairly close to the end of this hearing, kind of circle back to why we're here. And I think Representative Escobar, the gentlewoman from Texas, as well as Representative Musgrove-Powell, did an articulate job of doing precisely that, which is to say that fundamentally our democracy was attacked by a foreign adversary in 2016. And the Mueller report makes abundantly clear that that was the case. I'll refer the American public to page 3 of the contempt report. And I'll quote, "The redacted Mueller report contains numerous findings, including that the Russian government attacked the 2016 U.S. presidential election in sweeping and systematic fashion through a social media campaign and releasing hacked documents, and 2, that Russian intelligence services intentionally focused on state and local databases of registered voters and state and local websites affiliated with voter registration. For example, quote, the GRU compromised the computer network of the Illinois State Board of Elections, then gained access to a database containing information on millions, on millions of registered Illinois voters and extracted data related to thousands of U.S. voters before the malicious activity was identified." Here's the point. If I can leave the American people with one thing, it is this. If we don't take actions to prevent it, it will happen again. And that is why it's so fundamentally important for us to be able to discharge our constitutional duties by reviewing the Mueller report and the underlying evidence. And by the way, this is why I'm particularly frustrated today, because this is not an unreasonable request. As I referenced earlier in this hearing, I'll read a letter, April 25th, to the Attorney General of the United States that says, I'll quote, "In our prior letter, we made clear that for the committee to discharge its unique constitutional and statutory responsibilities, the committee requires full visibility into the special counsel's office's unredacted report, findings, and underlying evidence and information." That letter is signed by Congressman Adam Schiff and Congressman Devin Nunes of the Intelligence Committee. I am at a loss for understanding why my colleagues on the other side of the aisle, who I respect greatly, would not join in our efforts to be able to ensure that this committee and its distinguished members have access to the special counsel's report so that we can ultimately do our jobs. And given the Attorney General's unwillingness to allow us to do so, and this administration's engaging in wholesale obstruction of Congress to be able to engage in its oversight duties, we have no choice but to move forward with a contempt citation. And that's why I'll be voting no on my colleague's amendment, and we'll be voting yes in favor of the citation. And with that, I yield.
For what purpose does the gentleman from Pennsylvania seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I yield the balance of my time to my colleague from Louisiana.
I thank the gentleman for yielding. Mr. Chairman, I just want to make sure that we get something straight for the record, because if there is a court proceeding about this, this will be very relevant to the trier of fact, to the judge in that matter. You said in your own words, I think, just a few moments ago in response to my inquiry, that the subpoena that you issued, that this committee issued to the Attorney General, is just the next step in a dialogue. We're here on an extraordinary contempt citation. This is not a game. Your subpoena is issued to the Attorney General of the United States of America, and it reads in its first line, "You are hereby commanded." That is not an invitation to a dialogue unless we're going to construe it that way. And if that is the view of the chair, we need to make it crystal clear for the record right now so we can dispense of the court hearing that many of us anticipate to come out of this. This record will make that court hearing moot and unnecessary. This is a dialogue and not intended by the sender of the subpoena to be an actual subpoena, apparently. Look, the authority that we have in the Congress to issue subpoenas is a heavy one. We should not weaponize this. We can't be using this stuff for political purposes, and that's what's happening in this committee right now. Many of the legal rights usually associated with a judicial subpoena don't apply to a congressional subpoena. We have a huge weight of authority, and I just feel like it's being abused here. And I think the admission that you made just a few moments ago is extraordinary. It makes much of what we've done here today a total waste of the American taxpayers' time. And I'll yield back.
Yield back.
Mr. Chairman.
For what purpose does the gentleman from...
Mr. Chairman.
Oh, I'm sorry. Mr. Reschenfeld has the time.
Mr. Chairman, I yield the balance of my time to my colleague, Mr. Biggs.
Thank you. Thank you. I just want to make two quick points that I think have to be said. When I listen to some of my colleagues on the other side, and they talk about the Russian meddling, which is one of the findings in the Mueller report, there's nobody on this side of the aisle that is minimizing that. And there's no one over here that doesn't think something has to be done. In fact, it was the Obama administration under which that took place. That's when that took place. But we need to, both sides are culpable. Both sides need to fix that. But it has nothing to do with whether Mr. Barr has complied with the subpoena. That's why we're here, to see if he should be held in contempt. The subpoena in and of itself, as we've now discovered, was apparently the words within the subpoena were not what was intended by this party, by the chairman. That is a problem when you're going to find someone in contempt. Contempt says there was a specific order of performance to be made. You didn't make it. We're going to hold you in contempt. That has nothing to do with whether we all think something should be done about Russian interference in the most sacred right of being in a democratic republic, which is voting. But what it does have to do with is whether we follow the rule of law. And what I'm seeing today is
we will issue a subpoena. But when it comes time to enforce the subpoena through something called a contempt citation, we will start modifying what we really intended. That cannot stand, and with that, I'll yield my time to the gentleman from Colorado.
I thank the gentleman for yielding, and I just wanted to respond to my friend from Colorado. Rather than doing this on the plane ride back on Friday, we could do it right here in public. I don't think anybody on this side of the aisle disagrees that the Russians meddled, interfered, tried to influence the outcome of our election. And if this is what this is about, I'm absolutely in favor of proceeding and finding out more information and doing our job as oversight. A number of the folks on this side of the aisle were very adamant about our Article I powers when President Obama was in office, and a number of them are very adamant right now about our powers of oversight and take this very seriously. The issue before us is whether the president colluded, conspired with the Russians, and it's clear from the Mueller report that he did not. And so I think we need to move on and not attack the Attorney General in this way. I understand from the chairman that we are not after 6E material until we get an order from the court, that we are willing to only look at classified material in a secured setting. I think both of those things make a lot of sense. Then the other two categories of documents I really don't know enough about. I can't support the underlying motion in this case because I just don't know what the negotiations were, and I think this is premature.
Gentleman's time has expired. For what purposes, the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I've been amused over the last half hour or so listening to the sweet talk coming from the other side of the aisle. It reminds me of when I was courting my wife and trying to get her to agree to marry me, and I just wouldn't let her leave until she committed. And I just kept talking and talking and bringing up 6E and 6G and everything that I could. And so finally, 39 years ago, she agreed to marry me. So I won. But we can't let the Republicans win today trying to sweet talk us and trying to sweet talk the American people. The issue is not about 6E. Don't get it twisted. The issue is about whether or not the Republicans on this panel will be consistent with the vote that they took on the floor of the House on March 14th. And they voted unanimously in a rare form of bipartisan unity. We all voted 420-0 for a full release of the full Mueller report. What happened to change their minds about it? Because now they're trying to sweet talk us into not getting the report. What changed? I believe what happened was on April 22nd, my colleague from Georgia was able to go and view the unredacted report. He went by himself and he agreed that he wouldn't say anything to anybody about it, but now we have the Republicans in lockstep, all of them agreeing to obstruct our ability to get the report. They have rescinded their support of March the 14th, and I wonder why. Is it because
Would the gentleman
they
yield? I'll explain.
understand? Is it because they have seen the full report and now they don't want us to see the report because they are afraid that it implicates the president? What is the reason why they have changed their minds from March 14th to today? And with that, I will yield to the gentleman from Colorado. I would like to have an answer to that question. It's more than a rhetorical one.
Yes,
and
sir.
we'll give
the gentleman
time.
yield?
Sir, I appreciate the gentleman from Georgia yielding. I will just be brief, not to belabor the point with respect to 6E, but I do think this is an important clarification. The amendment that we adopted from Mr. Gates states simply, no provision in this resolution or report shall be construed as a directive for the Attorney General to violate federal law or rules, including but not limited to Rule 6 of the Federal Rule of Criminal Procedure. The Attorney General, there are a variety of ways in which he could have complied with this subpoena and complied with Rule 6. One of the ways, as has been discussed during this hearing, was to simply tell this committee that he believed that he could not produce the grand jury materials, but that he would join us in a request in a court of law to ultimately produce those materials. I will also say the members of the Intelligence Committee make a compelling case that there is another exception under Rule 6E that very well could apply. If you look to footnote 3 in their letter to the Attorney General, where they state, to the extent any such information relates to grand jury matters, Rule 6E of the Federal Rules of Criminal Procedure impose no bar to the disclosure of such materials to this committee under the exception set forth in Rule 6E, subparagraph 3, subparagraph D, which I'm new to Congress, but many of you were here when the amendments to Rule 6E were made in 2001. All right, and this relates specifically to information involving foreign intelligence, counterintelligence, grand jury matters involving grave hostile acts of a foreign power, and so forth. So the point being that there are a variety of different ways in which the rule can be complied with and the subpoena could be complied with. In this case, the Attorney General clearly, after much negotiation by the chairman of this committee, who showed great patience throughout this entire process, chose not to do so. With that, I yield back to the gentleman from Georgia.
Thank you, and I yield to the gentleman from New York.
Thank the gentleman from yielding. I fully agree with the gentleman from Colorado, obviously, but I want to say that we're making a big mountain out of a small part of this. And remember, the main thing we're talking about is not Rule 6E. The main thing we're talking about is the absolute stonewalling by the Justice Department, the Attorney General, and the President, not only of the unredacted Mueller report and the underlying evidence, but of everything. The President has said we will reject all House subpoenas. What we are dealing with here, and we should not lose sight of the main fact, is, one, a total stonewalling of Congress from all oversight activity, which is unprecedented in the history of the country, and two, the refusal to let the Congress see the Mueller report, the unredacted Mueller report, and the underlying evidence. And I would point out that the comparisons made to 20 years ago are completely off base, because 20 years ago, the entire Starr report, 445 pages and 17 boxes of documents, were handed to the Judiciary Committee, and we saw all of it. And the debate was whether how much of that or all of it should be made public or not. Public. No one is urging that the entire, that the redacted portions of the Mueller report and the underlying evidence all be made public. Obviously, there are parts that cannot be made public, but obviously the Judiciary Committee should make that decision, not the Attorney General of the United States, who is acting, who has misled the public, deliberately misled the public, and apparently misled the Congress as to the contents of the report, and has obviously a motive other than that, a motive to protect the President. He shouldn't make that decision. The Judiciary Committee should make that decision, as has been the case in every previous case. That's what's at stake today. I yield back.
Mr. Chairman. Mr. Chairman.
Mr.
Chairman, down here. Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Let's strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. Before yielding to ranking member, I just want to say a couple of things. First of all, most of us, as well as being on this committee or on other committees, I happen to be on the Foreign Affairs Committee, and we've looked over the years very closely at some of the abuses of the Russians, Putin in particular, all across the globe and in his own country as well. For example, killing his political opponents, literally, usually through other people, but it happened. Jailing reporters, basically suppressing any true form of democracy in Russia. In other parts of the world, we saw what he did in Ukraine, basically using his so-called little green men to take over Crimea, and then to brutally attack the people of eastern Ukraine, shooting down a civilian airliner, basically propping up Bashar Assad and bombing innocent civilians, being responsible for killing thousands and thousands of innocents. So it's not a surprise that in the Mueller report we saw that there's confirmation that he was trying to affect us here, in the probably the most significant democracy on the globe, trying to adversely impact our elections as well. We saw him do it in other parts of the world as well. Not surprising he was doing it here. But again, I just want to mention, and the gentleman from Arizona said this, and others have as well, that this happened not when Donald Trump was president. This happened under President Obama's watch. That's when it happened. And basically, a blind eye was turned on most of those occasions. We saw, you know, the famous red line in Syria where action was promised and didn't happen. And investigations were talked about. It was talked about doing something about the Russians, but ultimately nothing was done by the Obama administration to stop this. And a lot of times we wonder why. I think perhaps it's because most people expected Hillary to win the election, and I don't think he wanted to think that there was Russian hanky-panky involved in her winning. But that didn't happen. Donald Trump won, and so therefore it became a huge issue. But let's not ever forget that this happened under President Obama's watch. That's where action didn't take place. And if you want to study and go into dealing with the Russians and stopping them from doing this type of stuff, that ought to be bipartisan. We'll work with you on that. But this is nothing but politics. This is about the next election. This is about trying to demonize the Attorney General. That's what this is all about. The Mueller report didn't come out the way you thought it was going to come out. You're really disappointed about that. And now you're fearful that this Attorney General is actually going to look in to what the Mueller report should have been about. And that was about trying to influence an election, trying to tip an election into one party's favor over the other. That's what is going to be looked into now. And I think a lot of my colleagues don't like that. I'd like to yield my additional time to the ranking member.
Thank you. I appreciate that. And look, real quick, and I'm glad my friend from Georgia, who we've talked about many things, he is a sweet talker, and I'm glad his wife actually agreed. The problem is we're not sweet talking here. We're talking about a subpoena to the Attorney General. This is not sweet talking. This is a subpoena to the Attorney General. And we have been consistent. And how we know I've been consistent? Because I sat on the floor and actually debated this resolution. And the resolution says, except to all this will be released except to the extent in which public disclosure of any portion thereof is expressly prohibited by law. Nothing changed. There's no backing up here. Don't fool the American people. Don't try to tell them that something changed. Nothing changed in that process because you can read the resolution. The resolution says basically what we didn't say in the subpoena. The subpoena says you want everything. This actually said no 6C, no classified that you can't get. That's what the resolution said. There's been no backup there at all. And the main thing that the chairman just said is something here in the Intel Committee. I want to redress this. The Intel Committee is not on this subpoena. So it doesn't matter. I don't care what the Intel Committee says. The Intel Committee is not on the subpoena that was issued by this chairman in this committee. And on the point and the face of this document, it asks for all things. The main thing is not about dialogue. The main thing is not about underlying documents. The main thing is what does the subpoena ask for, and the subpoena asks for everything. One last question before the time runs out. And Mr. Chairman, you have cited on several occasions now discussing this, many cases where this has actually happened. Where we've had many cases outside the independent counsel statute. Please cite me cases in where this has happened, where the Attorney General goes with the committee to actually go and get this done. Outside independent counsel, which independent counsel actually said you're supposed to do this, outside of that, what are the cases? Outside of independent counsel, you stated on several occasions from the dais this morning and this afternoon that previous cases, this is the way we've always done it in previous cases. Our side can't find a previous case outside the independent counsel statute, outside the independent counsel, or a
Is the gentleman asking me a question?
Yes.
The gentleman yield?
I yield.
Well, for example, Watergate, Whitewater, the Clinton-Gore campaign finance case, Iran-Contra, the impeachment of Judge Hastings,
reclaiming
the
my
Mike
time.
Espy matter, for example.
Reclaiming my time. You just answered everything that I told you it was not. And that was, I said outside independent counsel or impeachment, which we had. I'll allow that I didn't say impeachment.
Those are not impeachment inquiries.
Again, the problem comes in here. My time has expired, and we need to, somebody else can take the time, but this is a problem. The subpoena doesn't say that.
I would remind the gentleman, and everybody for that matter, that what we were debating supposedly is an amendment over my alleged change of position 20 years ago, and nothing else. But we seem to have gotten a ferret from that. For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
The gentlelady is recognized.
Mr. Chairman, I have to report to you that I, over the course of the last 30 minutes, am slightly encouraged. I heard at least 2, maybe 3 of the minority members of this committee say they were upset about Mueller's finding of the sweeping and systematic interference in our election by Russia. I am encouraged. I have to admit, over the course of many months now, I have not heard Republicans say that. I hope that they share our outrage. I hope that they share our wish and will to protect our system of government and our elections. So it would follow, it seems to me, that they would also be outraged that what happened during that sweeping and systematic interference with our elections was hundreds of meetings with Trump and Trump associates, hundreds of contacts. That might have been during the Obama administration, but it was during the Trump campaign. I hope you share my outrage at that. The campaign welcomed, wallowed, invited publicly that interference by a foreign foe. And so it would also follow that the minority members would be outraged by what the Mueller report found in Volume 2, which, as hundreds of federal prosecutors have now signed on to a letter this week, says, each of us believes that the conduct of President Trump described in the special counsel Mueller's report would, in the case of any other person, result in multiple felony charges for obstruction of justice. Where's your outrage on that? That the president's effort to try to fire Mueller over and over and then falsify his efforts to do that? The president's efforts to limit the scope of Mueller's investigation so as not to investigate him. There's outrage to be had, and so it would follow. I'll conclude before yielding the balance of my time with where you took us last week, Mr. Chairman. You asked an important question. History is watching. Our children are watching. Our voters, our constituents, Americans are watching. Where will you be counted? Will you be on the side of obstruction? Will you be on the side of an administration that simply wants to darken the entire Mueller report, try to reclaim privilege that they've already waived? Where will you be? Will you sit silently? Will you argue on behalf of a president who has falsified everything, who cares nothing about the truth, who cares nothing about our system of government? Will you sit silently, or will you boost him up in his false claims? Or will you stand up for the rule of law? Will you stand up for the Constitution? History will judge us. And with that, I yield to the gentlewoman from Texas.
Thank you so much, Ms. Dean. I, like you, am delighted. It only took 6 hours into this hearing for us to finally get to what this is about. And this is about Russia's attacks on the United States of America. And so how, knowing, again, restating something I stated earlier, knowing they are still at it, knowing that they were so wildly successful, how do we prevent that? Who did it? Who aided and abetted? Who hid the truth? We've seen much of that in the Mueller report. We have not seen it all. And the reason that we need to see it all, and the reason, more importantly, that the American public needs to see it all, is so that we ensure it never happens again. So unless you are willing for it to happen again, I would hope that our colleagues on the other side of the aisle would join us and would actually be demanding with us to see everything. Let's see it all, so that we can then hold those accountable who should be held accountable, and more importantly, prevent this from ever happening again. That is well within our power. It's this committee's obligation and responsibility, and we invite our colleagues to join us in that quest for the full truth. Ms. Dean, I yield back.
Ms. Dean, would the gentlelady yield? Behind you.
I will yield. Thank you.
I thank Ms. Dean and Ms. Escobar. Their point, I believe, is who cares if it was President Obama who was the president when we were attacked? I don't understand that point at all. It was still the Russians attacking us. It's almost as if you're suggesting that we were asking for it because he didn't do enough to counter it, and now we should have to live with what they've done. I have spoken up against the response. I believe it was inadequate. I think Donald Trump was in their head when he said that the election was going to be rigged, and so they didn't want to counter that and reinforce that claim by Donald Trump. The response should have been stronger, but we were all attacked. That's the point here. It doesn't matter who the president was. The Russians attacked us. You should be uniting with us to stop that. I yield back.
On the amendment, all in favor of the amendment will say aye. Aye. Opposed, no? No? The noes have it. The amendment is not agreed to. If there are no other amendments, we can...
I have an amendment.
The gentleman from North Dakota is recognized. For what purpose does the gentleman from North Dakota seek recognition?
Mr. Chairman, I have an amendment at the desk.
Gentleman has an amendment at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary, offered by Mr. Armstrong of North Dakota.
The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. We've done a lot of this today, and there's a lot going back and forth, but let's remember what this hearing is about today. This hearing about today is about holding the Attorney General in contempt for violating a subpoena that he would have had to violate the law to comply with. We can talk about speeches, we can talk about interference, and we can talk about, we didn't really mean that he had to provide grand jury testimony, but we've spent the last hour and a half looking through any comments that have been made on news or in print or anything since this entire thing came up. And you know what's interesting? Not a single person has said we don't really want grand jury testimony. It is the full unredacted Mueller report. That's what the subpoena says. That's what the narrative is. So to have this reasonable dialogue after we've already committed to a contempt proceeding seems to be a little, if we're using phrases, I'll just use cart before the horse, different types of issues. What we did find, though, was the chairman on CNN stating that every other AG has gone to court. And outside of, I think, the ranking member making sure that's a misleading statement, it's a political argument and not an adequate reflection of the current status of the law. So let's make sure we at least understand what the current status of the law regarding release of grand jury testimony is. There is no federal code compelling the AG to go to court voluntarily to release grand jury testimony. The AG has the sole responsibility and prerogative to determine what DOJ's position will be on the release of grand jury testimony. There is no law that allows a congressional subpoena to compel the AG to go to federal court to release grand jury testimony. The chairman and the majority may want him to release that information. They may think they're entitled to that information, but they have by issuing a subpoena, you cannot force the Attorney General to release that or to go to court to release the information. And so we're offering the amendment, which is, and we have cited several different cases and have brought up for various different reasons. One of them is the Holderson case, Jaworski case. These are cases regarding impeachment with President Nixon. But one of the things we haven't done yet is talked about a case that was decided a week ago. And I think this is probably the most important thing that has been missed in this hearing is there seems to be a failure to recognize that there is no guarantee that the court would require the release of this information. And Wheeler v. Barr, which was just decided last month in the same D.C. circuit that we continue to cite from 1972, held that Rule 6E makes it quite clear that disclosures of matters occurring before the grand jury is the exception and not the rule, and sets forth in precise terms to whom, under what circumstances, or what conditions a grand jury information may be disclosed. Rule 6E restricts that persons bound by grand jury secrecy must not make any disclosures about grand jury matters unless these rules provide otherwise. The only rule to provide otherwise is Rule 6E3. So let's be clear about what we're doing. This isn't a fight between Congress and the executive branch. This is the fight between the Democratic leadership, the president, and their base. They know the American people don't want an impeachment proceeding. And if they want to continue down this rabbit hole and continue to have this type of showmanship, then let's at least be clear about what the status of the law is. And with that, I yield back.
Mr. Chairman, point of parliamentary inquiry. Mr. Chairman, point of parliamentary inquiry.
The gentleman will state his inquiry.
My inquiry, is it appropriate or is the committee permitted to vote on an amendment which, as far as I can tell, offers a legal opinion but doesn't modify the contents of the contempt resolution. It's an
It's
interesting.
not a proper parliamentary inquiry.
Okay.
Does the gentleman yield back?
Yeah, I yield back.
Okay, I will recognize myself for 5 minutes in opposition to the amendment. The amendment does two things. It says that my correspondence does not identify any legal basis to compel the department to request the does not identify any legal basis to compel the department to request the federal court order to share 6E material. Quite correct. It doesn't identify any legal basis to compel the department because we don't ask that the department be compelled to request a federal court order. It has nothing to do with anything. It's completely irrelevant. The second part says that the correspondence does not account for the recent D.C. court decision in McKeever versus Barr, which holds that a federal court does not possess inherent authority to release grand jury information protected under Rule 6E. The McKeever decision does say that, but it also recognizes various exceptions to enable federal courts to release 6E information, including for judicial proceedings. There is authority that certain congressional proceedings are the equivalent of judicial proceedings. We think that's an adequate legal basis. Beyond that,
They're impeachment.
Beyond that, we've debated the this amendment extensively in the last amendment, which is basically exactly the same subject matter. So I urge my colleagues to not waste to oppose this amendment because it is not accurate as to the correspondence, number one. It is not accurate as to the law, number two, and it is completely unnecessary and misleading, number three. I yield back. We'll take a vote on the amendment then. The question occurs on the amendment. Who seeks recognition? For what purpose does the gentleman from Arizona seek recognition?
Who would strike the last word?
Gentleman is recognized.
I yield to the gentleman from North Dakota.
Thank you. And just briefly, because I know it's been a long day, but the Attorney General thought it was relevant, which is why it was issued into a response to the chairman. So with that, I yield back to my friend.
I'll yield back, Mr. Chairman.
The question... For what purpose does the gentleman from Louisiana seek recognition?
Move strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to make a simple point. We have been here a long day. There's been some extraordinary admissions, I would submit, by the chair and those who have issued the subpoena. But I just want to quote one more time one line from the letter that the Department of Justice Assistant Attorney General Stephen Boyd sent to you this morning. It begins, "We are disappointed that you have rejected the Department of Justice request to delay the vote of the committee on this contempt filing this morning. You've terminated our ongoing negotiations and abandoned the accommodation process." And this is the important phrase. "As we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law." Some of our Democrat colleagues have conceded, I think, over the course of the last hour, that this 6E material, that there are ways to get around this, that in its current form and on its face, maybe the subpoena says one thing, but it really means another, and the chairman says, oh, this is just part of an ongoing dialogue. This entire charade today was premature and unwarranted. Our Democrat colleagues have effectively acknowledged that on the record. I think this amendment is one we should support because I think it is not a legal opinion, as Mr. Cicilline said. This is a statement of facts. The facts, the important facts that have transpired over the last couple of weeks in this good faith negotiation by an Attorney General that has been completely transparent and who is limited only by the written rule of law. He is trying to comply with that. Mr. Nagu said a few moments ago that, look, there are ways to comply, you can get around this and work with the subpoena. That's exactly what the Attorney General has been trying to negotiate in good faith. And yet we jumped the gun, we came in here, we've wasted an entire day when all these important issues are pending before the country, tying up the hands and the time of how many members are on the committee? 40 members of Congress are tied up into this? And it's only, as the chairman says at the end of the day, I just repeat it because it's so extraordinary that he admitted this in this rare moment of candor. Hey, this is really just the next step and an ongoing dialogue. We could have continued that dialogue without this charade. I'll yield back.
For what purpose does the gentleman from Georgia seek recognition?
I move to strike the last word.
Gentleman's recognized.
Mr. Chairman, all this sweet talk is just killing me. I know how my wife must have felt, and I'm so sorry. I'm going to go home and get on one knee and apologize to her for putting her through what we're being put through today. The stakes are too high, however, for us to yield to the sweet talk. Will darkness, secrecy, and obstruction prevail, or will truth and the rule of justice overcome the sweet talk? That is the question that we are here to answer today, whether or not we're going to issue this subpoena to obtain this information that the American people want and that the members of the House Judiciary Committee need in order to do our work. And with that, I'll yield to the gentleman from New York.
Thank the gentleman from yielding. I want to point out again that the amendment in front of us does two things. It points out that the language that my correspondence doesn't provide a legal basis to do something which we are not asking be done. That is to compel the department to request the federal court to share material. We've asked them to do it, but we do not seek to compel them to do it. And it doesn't take account of the decision in the McKeever case, which, however, does not bar a court from ordering the grand jury material, the 6E material, delivered to the committee under various conditions which we think we can meet. So it's totally irrelevant. More to the point, it is very hard to credit the good faith, so-called, of the Attorney General when for 6 weeks, starting on when he first misstated what was in the Barr report, in the Mueller report, misled the people, then for 6 weeks refused to talk to us, refused to negotiate with us at all about getting access to the unredacted report and the underlying material, only evinced a willingness to negotiate with us for that purpose when we threatened this contempt in the last week, waited till the last day, basically, to make an offer, made a ridiculous offer that only, or a couple of days earlier, made a ridiculous offer that only the chairman and the ranking member could see the material and then couldn't tell anybody about it, anybody on the committee or in Congress, so it was useless. Rejected our counteroffer, which said that members of the committee should have access to this material. And I would remind you that in all previous cases, members of the committee have had access to material. The question was whether the public should have access to it, not the committee members. And that was a decision for the committee and for the Congress. And we didn't break off negotiations. They broke off negotiations when we said we would go ahead with the contempt proceeding last night if they didn't make us a better offer. And they rejected our counteroffer. They didn't make us an offer other than 2 people can see it, 1 extra staff person. That was their counteroffer, but 2 members, and couldn't discuss it with other people. That was an insulting offer. They broke off negotiations. It leaves us no choice but to vote a contempt in order to enforce the right of the committee and the Congress and ultimately the American people to see this material, which very much implicates the president's campaign working with the Russians to subvert an American election, very much implicates the president in obstruction of justice. The special prosecutor said he didn't charge that basically because of the Office of Legal Counsel policy that you can't indict a sitting president for anything, no matter how much evidence there is. And we need to see, on behalf of the American people, all the material here and material that may be exculpatory, as people have pointed out, so that we can conduct a proper oversight in this matter. So I urge my opponents to oppose the amendment, but to keep in sight what's really at stake here. What's really at stake is the ability of Congress to do its job to protect the American people. I yield back.
Thank you. And Mr. Chairman, again, something bad must have happened from March the 14th when every Republican, along with every Democrat, voted for the release of the full Mueller report. And then March 22nd, when the ranking member goes to see, under a gag order, by the way, goes and sees the full report, and now everybody on that side doesn't want to release the report.
Will the gentleman yield? I can
Doesn't
answer your
pass
question.
it doesn't pass the smell test, and yes, I yield.
The answer is very simple. We voted unanimously to release the report within the bounds of the law. That's what the Attorney General's doing, and that's what apparently you keep missing. I don't understand why that's so difficult.
The sweet talk is obscuring the real issue, and we need to stop the sweet talk and get to business of voting on this resolution here. And I'd hope that all of my friends and colleagues on the other side would join us in preserving and protecting the rule of law. Thank you.
Thank you. I ask unanimous consent to enter into the record this timeline of negotiations with the DOJ beginning March 25th, and all the letters referenced in the from me to the department and in the other direction from the department to me, referenced in this timeline. Without objection, this material will be... You object?
Can I see it?
It's been attached to our press release.
Are we going to get? What now? Okay. And is this from you, or is this put together by the staff? As far, I mean, yeah, okay, by yourself. Okay, because again, part of this timeline, and we offer the timeline on the public negotiations, but we have no knowledge of maybe something that I haven't had a chance to read.
Well,
we've asked, and we're just asking.
This references, I believe, and you'll correct me if I'm wrong, this references only letters written by the department to us. And
it's fine, it's public, we're fine.
Without objection, then, this material will be entered into the record. For what purpose does the gentleman from Texas seek recognition?
I rise in support of the amendment.
Does the gentleman seek to strike the last word?
Yes.
Last word is duly struck, and the gentleman is recognized.
Thank you, Mr. Chairman. I agree with the chairman that it seems ridiculous that we have to go into SCIFs to review material that is classified, secret, privileged in some way, and not suitable for public release. We're not allowed to take our cell phones in. We have to leave those outside the room. We're not allowed to take notes, but if we do take notes, or in some cases are allowed, we have to leave the notes there in the room. We can't take them with us. We can't discuss anything anywhere outside the SCIF that we saw, heard, or read in the SCIF. And the chairman said, the Attorney General, in essence, said we could review the much more unredacted report in a SCIF, but we couldn't tell anyone. It sounds ridiculous, except those are the rules of the House for reviewing material that is not subject to public review. So it would sound ridiculous, except they're the rules. We have to follow the rules. We get into trouble when we don't follow the rules. Again, we're back to where we're going to ultimately vote. You have the votes to hold Attorney General Barr in contempt of Congress, which will be meaningless because you will never be able to enforce such a vote of contempt before a court of proper jurisdiction, because you cannot legally, before a court, have someone in contempt for refusing to do what the law says they cannot do. So, and that admission is what we got when the majority offered, oh, here's a negotiation. You agree to go into court with us to get a court order saying you can release the grand jury material. That is an admission of fact, an admission of law that the Attorney General cannot do what he's going to be voted apparently in contempt for failing to do. I applaud finally having an Attorney General that believes in following the law. And let me say, I totally understand the skepticism of the majority when anything is redacted, because we found out during the Obama years so often, and probably a majority of the time, when anything was redacted, it was making the administration look bad. It wasn't because there was something that was truly classified. So I can understand, having seen that out of the Obama administration, you might want to project that onto this administration. But what was clear about Attorney General Barr, frankly, I didn't know him. I didn't know if he'd be a decent Attorney General or not. But I've been impressed. He's trying to follow the law. He's trying to get to the bottom of things. And if this were Eric Holder or Loretta Lynch, then I don't have any doubt they would not have let you have any of the report if it pertained to their administration. So I thought the Attorney General bent over backwards to present what he did, and now he's going to be met with a vote of contempt. I guess this is the rule. No good deed goes unpunished. Attorney General Barr, maybe by a vote of contempt today by this committee, will learn the lesson that my late mama used to just say, there's some folks you just can't help. And with that, I will yield back.
Gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
I have a lot of good friends, Mr. Chairman, including yourself, a lot of good friends on the other side of the aisle. And I'm simply trying to clarify the consistency of the false narrative that has continued as a theme of my friends on the other side of the aisle. Chairman Nadler has been consistent, and we've been consistent. We've had three elements to our request. It has been modified to the extent of the two committees, Republicans and Democrats, of the Intelligence and Judiciary Committee, specific documents that we could specify, and 6E materials is a part of it, operable under the law, either the Attorney General and DOJ walking into court with us saying what can be released, or not opposing when we go into court to get a court order. The false narrative that the whole premise is on trying to get grand jury materials, and I'm sure the redundancy of this has strained the imagination of the American people. What is 6E? It only means that documents used in a grand jury, like you'd be down in your own backyard and you had a grand jury for a criminal case, those materials are typically not seen. In this instance, because of the need for the thorough investigation we have for the American people, we would use the courts. I want to move away from that. That is not the anchor of what we have requested. And then you cannot ignore the series of meetings and engagements that the staff has had. But what occurred in the last 24 hours was a Saturday night massacre of rejection. The DOJ stopped in its tracks of working with us. Can we understand that? They stopped in their tracks of working with us. And early in the morning, we received two letters dated May 8th simultaneously. There was no space to be able to engage in a discussion if you receive a letter of disappointment saying that we are not moving forward anymore. You have terminated our ongoing discussions and abandoned the accommodation. We're still engaged. Again, a Saturday night massacre of rejection. Simultaneously comes a letter that says we're going to ask for a blanket executive privilege on everything. What more do you think people who are fact finders can do if our negotiating partner has turned the lights out and implemented Saturday night massacre with letters rejecting our honest attempt to negotiate? Then they want to use the words of Mr. Nadler I'm glad that he is a gentleman that says that he has a right to change his mind, or he's been edified and he's always enlightened, and so he's gotten the light and seen the light, or has a different interpretation. That's just and fair. We say it in the open. But we have a colleague, Chairman Cummings, who's not here to defend himself. And so he was used to say that he's against subpoenas, and he said it 7 years ago. So let me just add into the record the words of the chairman of the Government Oversight Committee, Mr. Elijah Cummings. At the time of the Republican contempt vote 7 years ago, Attorney General Holder had already produced more than 7,000 pages of documents to our committee. To my knowledge, Attorney General Barr has refused to turn over any document. He went on to say the night before the contempt vote in 2012, and I remember this well, Attorney General Holder was really trying not to get a contempt vote. He found this particularly sensitive for his integrity, so he was working with the committee. Attorney General Holder personally came to meet with Chairman Issa and me and offered to provide copies of additional internal deliberative documents. Here, Attorney General Barr is blocking the production of the very documents that General Holder came forward to produce. He was like that in the Judiciary Committee as well. Then Attorney General Holder made a fair and reasonable offer to resolve the impasse after providing thousands of pages of documents and numerous interviews. Here, Attorney General Barr refused to even show up. So in 2012, Ranking Member Cummings did ask for a short delay to allow the committee to consider an 8-page legal document asserting executive privilege and an offer from General Holder to produce additional deliberative internal documents. Let us not establish a false narrative. There's apples and oranges from what happened in 2012. I would say to my colleagues, join us in this recognition that to do our job, we need the documents. Work with General Barr. If you cannot do that, then vote for the contempt citation. With that, I yield back my time.
The question is on the amendment. Those in favor say aye. Opposed, no. In the opinion, no. In the opinion of the chair, the nays have it, and the amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? The question occurs on the amendment in the nature of a substitute as amended. I'll take the vote in a moment, but I will remind members that after the vote on the amendment in the nature of a substitute, there'll be a vote on final passage. All those in favor of the amendment in the nature of a substitute as amended, respond by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the committee report for a resolution recommending that the House of Representatives find William P. Barr, Attorney General of the United States Department of Justice, in contempt for refusal to comply with a subpoena duly issued by the Committee on the Judiciary as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
And the ayes have it.
Roll call,
Committee
Mr.
report.
Chairman.
The roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell?
Aye.
Ms. Mucarsel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? No. Mr. Collins votes no. Mr. Sensenbrenner? No. Mr. Sensenbrenner votes no. Mr. Shabbat? No. Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? No. Mr. Jordan votes no. Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? No. Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? No. Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? No. Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Has everyone who wishes to be recorded been recorded? Has the gentleman from Tennessee been recorded? Does the gentleman from Tennessee wish to be recorded? How does the gentleman from Tennessee wish to be recorded?
Mr. Cohen votes aye.
We have two more people coming.
Mr. Chairman.
In the middle of a roll call.
Mr. Chairman.
Gentleman from Georgia.
After all the eloquent speech today and we're talking, I forgot, am I recorded?
Mr. Collins, you're recorded as no.
Thank you. I'll consider it be a no.
Madam Clerk, how am I recorded?
Mr. Nadler, you're recorded as aye.
I wish to be recorded as aye.
Chairman,
The gentlelady from Texas.
how am I recorded?
Ms. Jackson Lee, you are recorded as aye.
I think that's correct. Thank you.
Gentleman from Ohio. How is the gentleman from Ohio recorded?
Mr. Shabbat, you're recorded as no.
Mr. Chairman?
The gentleman from Rhode Island.
Mr. Chairman, is it appropriate for us to enter in a colloquy or in the middle of a vote or no?
It's the middle of a vote.
Then how am I recorded? That was what I was going to ask.
Mr. Cicilline, you're recorded as aye.
Thank you. That is correct.
Mr. Chairman.
The gentleman from Louisiana.
Mr. Richmond votes aye.
How many more do we have?
Mr. Chairman.
Who seeks rec? The gentleman from Maryland.
Could the clerk please tell me how I'm recorded?
Mr. Raskin, you're recorded as aye.
Thank you very much.
Who seeks recognition? How is Mr. Johnson of Louisiana recorded?
Mr. Johnson of Louisiana, you are recorded as no.
We for the benefit of members and everyone else present, we have two members coming back from a hearing. We're going to hold the vote open until they get here momentarily.
Okay, never mind.
We're going to hold the vote open until they get here momentarily, hopefully momentarily. People don't have to keep asking how they recorded. On this vote, everybody should be able to be recorded. The gentlelady from California?
Ms. Lofgren votes aye.
The gentlelady from Washington?
Ms. Jayapal votes aye.
And the two of you are very welcome to cast your votes. Has anyone else who wishes to vote not voted yet? The clerk will report. Yeah.
Mr. Chairman, there are 24 ayes and 16 noes.
The ayes have it, and the committee report as amended is ordered reported favorably to the House. I now recognize the ranking member, the gentleman from Georgia.
Thank you, Mr. Chairman. Pursuant to Clause 2L of Rule 11, I hereby to give notice of intent to file dissenting views for the inclusion into the report.
The notice is duly noted. Members will have 2 days to submit views. The committee report will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and without objection, staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all of our members for attending. Without objection, the markup is adjourned.